Yes.
May please, your lordships. Sir, I beg to mention one urgent matter. On 21/11, suspension matter, your lordship.
Motion.
No, my lord, by admission.
If it's admission, you take it up before the registry. Okay. Yes.
With please, your lordship. With the concept of the other side, my lord, I beg to mention item number 6, my lord. Here, my lord, I am going to file a reply today, my lord. So, my lord, the matter will come up next week, my lord.
You are Mr.
Yes, Hawk, my lord.
Mr. S. Hawk, learned counsel for the petitioner, submits that
6.
he will be filing a reply affidavit during the course of the day. And therefore prays that the matter be listed again after a week,
The date may be fixed, my lord.
as prayed for,
Next week, my lord.
that the matter be listed again. Give it 2/12.
My
Hmm.
Okay.
My lord, I beg to mention one writ petition urgent matter, my lord, which is filed 17/11/2025. Filing number 14747. May kindly tomorrow, my lord.
What is the urgency?
Urgency, lordship, compensation matter, my lord.
Huh?
Service matter, my lord.
There is no urgency as such. It will come in due course.
Monday, my lord.
You tell me the urgency. The service matter is not urgency.
Lordship,
Will come in due course. You have filed yesterday only.
17/11, my lord.
I know. 17/11 is when? Monday. He'll come. He'll come. We'll have it on Wednesday next. All right.
Yes, my
26.
lord.
May it please the lord.
26.
26.
Also, I beg to mention
My
item
lord.
number 5, my lord.
Item
number
five.
5. My lord, this matter, we have received instruction today, my lord. May come after 2 weeks, my lord.
Instruction today.
My lord.
Then you want to file affidavit?
My lord, we want to file a affidavit.
My lord, I
Yes.
appear on behalf of the petitioner sir,
Uh,
in this matter.
yes.
A fixed date may be.
Ms. S. Sutia Lanet, Standing Council Elementary Education, submits that she has received the instructions and requires how much time? A week's time, 2 weeks' time to file the counter affidavit. As paid for, list the matter again on so and so, 9/12.
Deeply obliged.
May I please, your lordship. Your lordship, item number 16. Your lordship, the conducting advocate is not present today, your lordship. His newborn baby having some issues. He had to leave yesterday. Any
16.
date, your lordship.
16.
Item number 16, your lord.
Who is the council?
Your lordship, he had to leave yesterday for his newborn baby issues.
What is his name?
Yeah, R.A. Chaudhary, your lordship.
Mr.
Any date,
R.A.
your lordship.
R.A. Chaudhary, learned conducting counsel for the petitioner, is said to have some personal difficulty to conduct the case today.
Paid
as
for
paid for on his
26,
behalf.
27.
Matter stands adjourned for 2 weeks.
Wait, please.
Yes.
Item number 13 and 14 of
Please.
today's list, my lord.
Uh.
We are seeking some accommodation. We are making a joint prayer, my lord. Can it be on next Tuesday, my lord?
Why?
Well, today we have some difficulty, my lord. The other party also has some.
Okay, on the joint prayer of the learned councils for the rival parties, list again after a week. Okay.
If fixed it.
What fixed date?
May I please, your lord.
Public.
May I please, your lord.
Yes.
Lord, so I beg to
There's
mention.
interim protection that may be continued, my lord.
Then we have a fixed date. List again on so and so. 2/12. Interim order passed earlier shall continue till that date.
Can it be 9/12? 9/12. 9/12. Or your lordship can have it Tuesday, next Tuesday
No,
also.
no,
Tuesday or Thursday. Or
Next Tuesday or Thursday, my lord.
9.
Public.
May I please, your lord. Lord, so I beg to mention for listing for admission, lordship. It's a cover matter, lordship. Last
Uh,
posted in the month of April, lordship.
Take it up
I
with the
approached the registry also, lordship. This is
Approach again.
covered by Upenda's, lordship. Matter is for
Approach
non-payment
again.
of non-payment
Approach
of, lordship, minimum pay scale, lordship.
Approach again, they will list it.
Lordship 124,
Approach again, registry. They'll take.
26.
No, no, no. Don't give any dates.
Lordship.
You go to the registry and write it down the registrar and get it listed.
Lordship.
Next, please.
May I please, your lordship? Lordship, I beg to mention item number 2. With the consent of other side, lordship, the item may kindly be adjourned for the day. The senior counsel, lordship, Mr. H. Rahman has some personal difficulties, lordship.
Mr. H. Rahman, learned counsel for the petitioner, is said to have some personal difficulty to conduct the case today. upon a payment on his behalf and not objected to by the other side. Matter stands adjourned for 2 weeks.
Lordship, if it may be fixed on the second.
No.
week of Jan-
2 weeks on a date to be fixed by the registry.
I'm obliged.
Next,
May I place your lordship, I beg to mention item number 4. My senior is on legs. So matter may be possible for timing.
okay, let the matter be called. Why are you mentioning now?
May I please, your
Yes,
Lordship, I beg to mention a writ petition for listing, your Lordship. Here, your Lordship, the urgency that matter pertains to provincialization, your Lordship. And the one of the petitioner is going to retire in the month
uh,
of December,
case.
your
It's
Lordship.
a new case.
Lordship, not new
case.
case, Lordship, it's
Then-
pending since 2022, your Lordship. And
Then
your
you
Lordship,
approach the registry for that.
we approached 2 times before the registry, your Lordship. But matter has never been listed, your Lordship.
No, you approach again, you get it written in the register,
He is going to retire in the month of December, your Lordship. For that reason only, your Lordship.
right in the register,
We
will be
have
taken up.
written that thing, your Lordship, but matter has never been listed, your Lordship.
We'll see, we'll see. You approach again. Yes,
Lordship, with the consent of the other party, would like to adjourn the matter for 2 weeks, Lordship.
which one?
Item number 8, Lordship.
Why do you want adjournment?
In 2 weeks, Lordship.
Why
Due to
do you
some
want
personal
adjournment?
difficulty of my senior, Lordship.
What happened to your senior?
Personal difficulty, Lordship.
What happened to your senior?
Some illness, Lordship.
What illness? Tell me.
Cold fever, Lordship.
We might able to prescribe some medicine also. What illness? What is the illness?
Sir, cold
Headache.
fever, Lordship.
Stomach ache,
No, Lordship, cold fever due to the.
Fever.
weather. I apply for the response 1 to 5, Lordship.
what is the matter? What is the matter regarding?
Lordship,
What is the matter about?
it's regarding the selection of professor in Dibrigarh University, Lordship.
This is a case of 2017.
Yes, Lordship.
Why should we adjourn it? Are you ready to pay cost for adjournment? You understand what I'm saying?
Lordship.
Matter is of 2017. Already 8 years have passed by. Why should we adjourn it?
Lordship, let the matter come up.
Let it come, call your senior, let him argue. Yes,
What is written 20 of the Sunday list?
we'll pass it over for some time. Maybe the council is not aware.
Petition item 1 of the daily list.
My lord, this matter is pertain to elementary department, my lord, as per my instruction here, my lord. So, this is my instruction. And one notification also there here, my lord.
What is the matter regarding Mr.
My
Bhuyan?
lord, the matter relates to, my lord, we have twofold prayer, my lord, that my suspension period is to be regularized. And my salary, my lord, is required to revise under the 2016 revision of pay rules, my lord. Till date, my lord, I have been paid with the revision of pay rules of 2010, my lord. It has not been fixed as per the subsequent revision of pay rules, my lord. Now, a new rule is going to become very shortly, my lord.
What is your post?
My lord, my post is the head mudaris. Now it has been, my lord, converted into, my lord, headmaster of an upper primary schools, my lord. My lord, pursuant to this honorable court's order, my lord, my services had been provincialized. And thereafter, my lord, I have been paid the salary not in accordance with the provision of the revision of pay rules, which was applicable at that relevant period of time, my lord.
All right.
It had been paid in a reduced rate. So therefore, my lord, I made representations and a proposal has also been sent to the department, my lord, for the purpose of payment of my arrear as well as the other dues, my lord. That has not yet been paid, my lord. 2020 matter, my lord, no affidavit till date, my lord.
What is your instruction, Mr. Sharma?
My lord, here this matter is under the jurisdiction of the elementary education department, and to this effect, my lord, one notification is published, and here it is stated, my lord, may I read, my lord? In pursuance of the government notification issued by number so and so dated 12/2/2021 towards conversion of all the erstwhile madrasa into general school, and accordingly all the pre-senior madrasa have been converted to ME school, and in consideration of the fact that the Director of Elementary Education is the administrative and controlling authority of all the ME school, and Director of Secondary Education is the administrative and controlling authority of the high and higher and senior secondary schools. The Governor of Assam is pleased to allow shifting the administrative control of all such converted ME schools to the Director of Elementary Education.
Mr. Bhuya,
Well,
now it has shifted to
my
11.
lord, what has happened, my lord, as per the instruction, my lordship knows, my lord, all the madrasa institutions, my lord, in the state of Assam had been repealed. And my lord, it had been converted into, my lord, schools. Now, these categories of schools, my lord, originally was upper primary level elementary schools, my lord. Madrasas. Now, that has been converted into, my lord, now upper primary elementary level school, my lord. Now, my learned friend have the instruction, my lord, that it has been taken up by the elementary level, my lord. Earlier, the administration
So
management.
what are you supposed to do then? You are to treat them elementary.
It is their discretion, my lord, how they respond, because we have made all the necessary parties, my lord.
No, you have not made. Elementary is not a party.
My lord.
You implead them. That's all. On the prayer of Mr. A. Bhuya, learned counsel for the petitioner, placed again after a week, in order to enable him to file appropriate application for implement of elementary education department. Before that, you write first sentence. Mr. U. Sharma, learned standing counsel,
Secondary Education.
Secondary Education Department submits that the government of Assam has recently issued a notification on 1/7/2024, wherein the erstwhile madrasas and all preschool madrasas have been converted into ME schools.
Pre-senior madrasa.
Pre-senior madrasas have been converted into ME schools, and therefore the administrative control has been shifted to the Directorate of Elementary Education. Stop, then the first sentence that you file application, we'll see how
My
to
lord.
proceed, all right?
My lord.
Item
Obliged.
3,
If there was an order of 17/7/2025, wherein the respondent number 4 was supposed to get some instruction. Lordship, today he has informed me that he is indisposed, Lordship.
Who is in the post?
He is indisposed. The
Who?
counsel for the respondent number 4, Lordship.
Who is that?
PJ Saikia.
He was here yesterday.
Yes, but today, but he was supposed to get the instruction, Lordship. There is an order of 17/7/2024.
Mr. PJ Saikia, learned counsel. Respondent number 4 is said to be indisposed. On a prayer made on his behalf, list the matter again on Monday. On which date he will apprise the court about the instructions
Lordship,
he was required to secure.
I am appearing on behalf of the Higher Education Department.
Mr. D. Upamanya, learned counsel, appears for the Higher Education Department.
Lordship, R.K. Talukdar, behalf of Accountant General. R.K. Talukdar.
Your name?
Tinlong on behalf of R.K. Talukdar.
Sorry?
Tinlong.
Tinlung. Ms. Tinlung, learned, give Learned Counsel appears for the Accountant General, Assam.
Item 4. কোন স্যার ইয়াতে নাই ন হ্যাঁ এইটো নহয় এইটো ফুলকাষ্ট স্যার না এইটো রেসপন্ডেন্ট meet with your lordships. Petitioner before your lordships was working ফুলকাষ্ট নাই who কাৰ হৈ বিহাবত আছা তুমি no this is 4 item number 4 respondent is education department. Petitioner before your lordship was working, my lord. Order dated 6/7/1994. Before the provincialization of the school, my lord. He was appointed 16/11/1993, my lord. Then his government approval also there, that is 6 July 1994, my lord. Then they have been working since then. In the meantime, school has been provincialized in the year 2013, my lord. But his name was dropped. Then what happened? Then after that, the school has been amalgamated, my lord. Annexure 7, page 40.
Ms. Devi,
Yes,
before that, you're not going to file the rejoinder?
yes.
Rejoinder affidavit?
Actually, this case is covered, my lord. I have already annexed one copy of this honorable court losses.
So you will not be filing rejoinder affidavit?
No, I have filed reply, my lord.
Where?
It is there. I have already filed. Page number is,
Page number?
it starts from 88.
88,
88, my lord.
but it is not
Up to
here.
91.
Huh?
I'm not filed. It is
Office-
88
no,
to
office
91.
It's
It is not there, my lord. Oh,
Office note says rejoinder affidavit has not been filed till date.
but I have already filed. When you have filed? When? You have to file a when? Where is the date? No. You have not written the date. My lord, let the matter be listed in another Thursday, my lord. In the meantime, my lord, call for the rejoinder, my lord, because I have already filed.
They give me the filing number,
Number is not there.
then
When you have filed?
from where we'll call?
Okay. You just remember, but you don't know the number.
Although,
Yeah,
please write, Ms. K. Devi, learned counsel for the petitioner submits that rejoinder affidavit has been filed, but from the record, it is seen that the same has not been filed.
yes, my lord.
Stop, Ms. K. Devi prays for a week's time to do the needful. List again after.
My
a
lord,
week.
fix a date, my lord, because the, since 1994, his service is not regularized.
List
Next
again after
Tuesday,
a
my
week,
lord,
you
or next
cancel that.
Tuesday.
When can we list, give it? First week,
First week of December,
yes, give a date,
give me a date,
list on 4/12.
4/12.
Yes.
Highly obliged. No, na, to talk to nine, no?
Ma'am, this is covered case by the order annexure 5, my lord, 173. Other several matter has also been disposed of with a with
Before saying covered case, you tell me what is the subject matter?
matter is the petitioners are the grade 4 employees in upper primary school of various district in Assam. And
Grade 4 employees.
yes, my lord.
Okay, then
They have, their service has been provincialized by order dated 23/9/2022, annexure 4, my lord.
page number
Annexure 4, page number 102 to 172.
172.
102 to 172.
102 to 172.
Start from 102,
Yes.
102 to 172.
That's what. How many petitioners are there?
Yeah, there is petitioner 93, my lord.
93 petitioners.
Yes, my,
So you are grade 4 employees
yes, my lord.
in upper primary school.
Our upper primary school.
Okay. Provincialization 23/9/2022.
Yes, my lord.
Thereafter,
Thereafter, they have been salaried in a fixed salary, 8,000 only.
Hmm.
And some similar situated person has filed a writ petition in division bench, and honorable division bench has passed an order to consider their matter with 8 weeks, and which is pending before the department. And this person has come to bring this similar order, my lord.
Division bench.
Yes, my lord.
Who went before the division bench?
My lord,
Who has gone to the division bench?
the other part petitioners
Ah, why?
for challenging the act, some provision of the act 2017.
Where is the order of the division bench?
My lord, Annexure 5, page 1, start from 173. Relevant portion.
How many petitioners were there in that case?
There are petition 148.
No, in the division bench case,
Yes, my lord. In division bench, 148 petitioners. were-
148.
Yes, my lord. Several cases were there.
Okay, it is a common order.
Yes, my lord, common order. There are 4 cases, my lord.
The challenge was regarding certain provisions of the 2018 Act.
Yes, my lord.
So please tell me, how is your case covered?
My lord, since there is no professional qualification is need, and we have also the same situated person along with those person who have filed the writ petition before the division bench, and
I think you should read the judgment, read the order.
may I read?
You read the order. Page 334. From paragraph 2.
The petitioners herein are not non-teaching staffs member, including senior assistant, library assistant, grade 4 employees, and other working in various colleges, higher secondary schools, senior secondary schools, high schools, and high madrasas throughout the state of Assam. The petitioners have been serving continuously in the.
Just a minute. You are upper primary school.
Yes, my
So
lord.
here there is nothing mentioned about upper primary. It's higher secondary, so senior school, then high school, then high madrasa.
Yes, my lord.
You-
There is another.
You are upper primary.
Yes, my lord. Here I'm, in this case, I am here upper primary.
That's why. So there is no mention about upper primary here.
But my lord, the case number is here, my lord, in this judgment.
What case number?
The other upper primary schools has also filed a writ petition for that bench. That case number has also been mentioned in this case.
Where?
And-
I think you better read. You'll not be able to find out like that unless you are ready.
My lord,
Please read.
the petitioners here are non-teaching staff members, including senior assistant, library assistant, grade 4 employees, and other working in various colleges, higher secondary schools, senior secondary schools, high schools, and high madrasas throughout the state of Assam. The petitioners have been serving continuously in the institution managed by privately managed communities. However, recognized by the government, and these institutions are defined as Bansar educational institutions. The state of Assam enacted Assam Bansar Educational Institution Provincialization of Service Act 2011, hereinafter referred to as the Act, with an objection to provincialize these schools as well as the provincialization of services of teaching and non-teaching staff, hereby bringing these schools and the employees thereof under the government form. The names of the petitioners, along with other eligible non-teaching employees of the Bansar educational institutions, were recommended for provincialization under the Act. Though the services of many non-teaching staffs were provincialized in terms of the Act 2011 in phased manner, however, pending recommendation of this case of the petitioner, the Act 2011 was struck down by coordinate bench under its common judgment and order dated 23/9/26.
Just a minute. Any counsel from the elementary department? Elementary education? Admission hearing is going on and you are sitting at the back. Later on, after 1 hour, don't say that I want adjournment.
Sit.
Counsel says it's a covered case, so he's reading the judgment. You don't have the brief with you.
So kita কিছুমান জেনবেন্সে সরি একটা জাজমেন্ট আছে ইয়াত পিছতো কি আছে
I may be allowed to. Kindly, madam, is taken after some time.
So why are you sitting there behind? You don't know this case has been called up.
Sorry, madam.
This is not the way you see.
My lord, in this case, we have not received any instruction also, so sometime may be allowed to go through this.
The court has to ask you, do you have anything to say? Please come forward, please come here. Then you come here and say that you have no instruction and take time.
In the last occasion, the honorable.
I'll reflect this in the order of the court. If you do the same, if you have this kind of, you practice this kind of, like, not be.
And it may be taken on monthly, my lord.
Why?
My lord, I have to go through this judgment. my lord.
Go through the judgment. We'll
Yes,
take it up
madam.
after some time.
Similar matter, there is supplementary 19 also.
We'll see about that. Just go through about the judgment. If it's a covered case, we don't have to hear it also.
19 or.
Tell the court, what is the situation? Whether it's a covered case or not. Go through it. Time being. That was item 7.
Lordship will kindly peruse the order dated 18/6.
Hmm? 17?
Lordship will kindly peruse the order dated 18/6/2025. Certain records were called from the department, Lordship.
Lordship, on the last occasion, Lordship, this honorable court was asked to produce the document with the appearance of that petitioner before the committee and on the draw of law.
Not the appearance, with
Just a
regard to
minute.
the concept.
Just a minute.
Yes, Lordship.
What is the matter regarding?
Lordship, issue is with regard to appointment to the post of principal. The petitioner has been fighting the legal battle since 2020, Lordship. Initially, the issue was with regard to his B.Ed degree, which has been held to be valid by this honorable court by honorable single bench, again in a writ appeal. then it was directed to be reconsidered for the appointment. After that, they have passed an order at page 70, Lordship, which is under challenge in this writ petition,
Post of principal,
post of principal.
in which school? School or college or
It's a secondary school, Lordship.
secondary school
Senior
principal?
secondary school, Lordship.
So who are eligible for that? Petitioner as well as?
As well as the private respondent, Lordship.
Okay,
He's-
now they want to
He's
adopt.
holding the post, Birendra. The private respondent is holding the post
Holding
of
the-
principal as still on the strength of a order which was initially passed in 2020. However, on order of this honorable court, that order was directed to be reconsidered by the department. Department has reconsidered and found the equal marks for both the candidates, petitioner and the private respondent. Now, what the department has done, they have drawn a lottery.
Hmm.
And they have picked up the name of the private respondent and he was allowed to hold the post of principal. We have challenged saying that there is other methods which could have been adopted, not a lottery. Now they say we have consented to lottery and that's why we cannot claim it back. Which is, we denied it entirely. In fact, we have submitted a representation before the order was passed that we do not consent to the lottery.
Okay,
So,
so the post is on a substantive basis,
yes,
not in charge,
not in charge. It's a,
substantive basis.
yes, Lordship.
Principal of higher secondary school,
Senior secondary school.
senior secondary school. What is the difference between senior secondary school and high secondary school?
That'll be same, Lordship. Name is senior second. That's why I've stated the name.
Okay,
So now the order is at page 70. The question was with regard to if they can
where's
hold a
the,
lottery for selecting a
where's the order? Page
70. It's a type copy, Lordship.
17.
70.
Okay,
The relevant part would be at page 72, Lordship. The background is given from 70 to 72 starting. And this third paragraph, it was type copy.
so what is wrong in the drawing of lots? If both of you have equal marks.
Lordship, what we have stated is that advertisement doesn't prescribe with regard to lottery, the first thing. And second thing is, Lordship, they already have Lordship will come to page 77. They already have a methodology when it is similar marks what the department does. Only in case of, though it is not directly connected to the recruitment of secondary education principal, Lordship, but there is a notification which was issued in 20th September 2023. Lordship has found it page 77, Lordship.
Yes, take me to the relevant portion.
Yes, Lord. 78, that would be 1, 2, 3, 4, 5, 6, 7 paragraph, Lordship. It starts with provided in 78, that is a relevant person.
Read.
Provided that in case 2 or more candidates obtain equal marks in aggregate, the candidate getting comparatively higher marks in B.Ed examination shall be preferred, and if such situation again prevails, then seniority of the AS shall be preferred.
Hmm.
That is the methodology they themselves have notified for other recruitment, but only in the case of the petitioner, they have gone into lottery.
This is in respect of Assam secondary education,
Yes, Lordship, same department,
same
issued by
department.
the same commissioner, Lordship.
This is also secondary.
This is Assam Secondary Education Government Service Rule. Lordship, what we are trying to say, though it may not be binding as it is not with regard to the same post, however, it is the same analogy they could have adopted, Lordship.
No, you are aspiring to be the principal of the secondary school.
Yes, Lordship. We are only referring to the notification with a persuasive argument that that could have been a process they already knew. They have already adopted, notified.
Mr.
However-
Counsel, I understand that. What I'm trying to say is that you also belong to the secondary school
Yes, Lordship.
principal.
Yes,
This rule is also regarding secondary education only.
it Government School Services Amendment Rules, Lordship.
Will it not apply? Service, it says. This rules applies to whom otherwise, mainly
This is not to the principal, Lordship. It will be the direct recruitment to teachers.
teachers. Okay, but it
But the
belongs to
same
the
department.
same department.
In fact, the same commissioner has signed the both
No,
notification.
Anyway, that's all right. So you say that a similar principle should have been adopted
Absolutely, Lordship.
in your
In
case.
fact, other courts also have gone into that when there is a similar marks that the seniority would be considered, otherwise they are qualifying marks in the examination.
So now the lots have been drawn already. Lots have been drawn already.
Yes, Lord. And allow the
And the respondent number
private respondent, Lordship.
4. Respondent number 4 has been
Yes, Lord.
selected.
He is already holding since 2020. However, as it was directed to be reconsidered, it was reconsidered again in December 2024 as per the order of this honorable court.
Where's the order?
Lordship, order will be at page. There are two orders, Lordship. One is by the honorable single bench. That is at page 46, Lordship. It starts at 46. That is the initial part of the litigation when we came for against the rejection saying our BA degree was not valid as per NCT. Lordship will come to the relevant part would be at page 62, Lordship.
Who has gone in appeal?
They have the private respondent number 4, Lordship.
Then before that, what was the decision of the learned single judge?
Lordship, that is at page 67.
Who had gone before the single judge?
We have come before the single judge saying that as our candidature was rejected, saying my BA degree was not valid as per NCT recognition, Lordship.
No, the single judge, who is the Biren Saikia? You are Biren.
I'm Biren Saikia.
Okay. And you have filed appeal also?
I've not filed an appeal. Appeal was filed because the order said my BA degree is valid, so my candidature should be reconsidered.
Okay, okay. Both of you have the same first name.
Yes, Lordship.
That's why it's
Lordship.
confusing.
Now he private respondent file a appeal before this.
No, just a
division.
minute. We'll go at a time. First of all, you come to page 40.
Page 40, Lordship.
This is your writ petition.
Yes, Lordship.
What was the challenge here?
In the first writ petition, we challenged the rejection order whereby my candidature was rejected to be selected as a principal because department held my BA degree to be invalid as per the NCT recognition is concerned. They said the college I passed in 1996 was not recognized under the NCT, Lordship.
Okay, then what is the outcome of the writ petition?
Writ petition was allowed, Lordship. That Lordship will come to page 62, Lordship. Page 7, paragraph 17, if I may read.
Yes.
The facts which are not in dispute that the respondent number 7 writ petitioner took admission in BA.
No, just a minute. From paragraph?
Lordship,
Don't read the writ appeal order. Read the writ petition order.
Lordship. Paragraph 17, page 54, Lordship.
A reading of the proposition.
Proposition.
Read that.
A reading of the proposition of the Honorable Supreme Court makes it discernible that the course that was undertaken in that given year when the recognition was refused would have to be allowed to be continued, and whosoever acquires BA degree pursuant to such course undertaken would be a valid degree. Nothing can be read in the proposition of Honorable Supreme Court that the final examination also has to be passed at the end of that year itself and not later, inasmuch as the relevant aspect of consideration is the course that was undertaken in the given year, not the examination which was passed. Accordingly, by placing complete reliance of the proposition laid down by the Bhupendranath Tripathi, we are unable to accept the views of the respondent in the secondary education department that degree obtained by the petitioner in the circumstance narrated above from Biporia PGT College would be an invalid degree under the law. Accordingly, we remand the matter back to the Director Secondary Education Assam to examine the claim of the petitioner as regards his claims for appointment as regular principal of Kheraska Senior Secondary School. In doing so, the respondent number 7, Biren Bora, has already been appointed as regular principal of Kheraska Senior Secondary School. The hearing under the law be also given to Biren Bora in respect of any such decision that may be arrived at. So now they have challenged this in a writ appeal, Lordship. The relevant part will be 63 again. Writ appeal was dismissed, since there is no infirmity in the order of the Honorable Single Judge, Lordship.
It was not interfered with.
Lordship.
It was upheld.
Yes, Lordship.
Then
Then they have passed that order at page 70.
770.
70. That is the order which we challenged in here, saying there cannot be a lottery. Now, the reconsiders the candidature of the petitioner as well as respondent number 4. They come to a finding that equal marks have been obtained. Now they will draw a lottery on consent.
So how have they say that there's a consent, is it by oral consent or by writing?
They're saying it's oral consent, which we dispute. We'd never given a consent. They have only recorded it.
So oral consent only.
That is what. And
So this is difficult to prove, isn't it?
absolutely. And on that basis, Lordship has asked the
Tomorrow you
record.
may say yes, day after tomorrow you say no. Nobody knows about it.
Lordship, in
No
fact,
written consent.
no written. In fact, on 3/12/2000, same year, 2024, we filed representation saying we have not consented. So that may not be taken in because it was stated at the time of hearing that lottery will be drawn saying you have agreed to it. Our representation.
So
will be
that's how you're here again before this court.
Yes, Lordship.
Isn't it?
Yes, Lordship. We only.
Now-
Maybe
Where's your pleading to that effect? Let us see
pleading to
your
the
writ
Lordship.
petition. Pleadings about the not consent not given
Lordship.
and other methods are there.
Lordship.
Supposing the lottery was in your favor, then what will you say?
Lordship,
You don't accept it.
we have not, we have not given consent and we also not.
No,
added-
no, I'm just saying hypothetically, supposing lottery was in your favor,
Lordship.
then will you complain?
Of course, Lordship.
You will
because
not
that-
complain.
Uh,
You will not complain. you'll
We have not,
accept.
at the initiation of the lottery, we did not agree. So the results was not in even our consideration to say, it, to accept it or deny it, Lordship. We said no lottery. In fact, respondent number 4 also said no to the lottery. But as Lordship, it has fallen from Lordship, he has agreed and he has not challenged it.
Now, so where is the pleadings? Let us see.
Page 15, Lordship, paragraph 28. Pa- Page 15, paragraph 27 and 28, Lordship. Petitioner continued to object and requested not to pass any order conducting selection process by relying on lottery to break the tie between petitioner and respondent number 4. Respondent authorities, however, did not pay heed to such request and informed during the course of hearing that they would rely on the lottery results and pass orders accordingly. This pertinent to state herein that if the order dated 12/12 is allowed to continue to operate, the petitioner would be deprived of his legitimate dues to be appointed as he is in his fag end of his career, Lordship. Even 28, the being soft and surprised, petitioner on 3/12/2024 approached the Honorable Education Minister, the respondent number 1 and 2 by filing representation and vehemently objected to the method of lotteries and stated that appointing or rejecting a candidature in recruitment process by way of lottery is illegal and prayed to break the tiebreaker by other methods to be considered, Lords. We have also filed representation before the order was passed. Or only prayer, it may be reconsidered as per the law, not by lottery, Lords.
Or you want one more lottery?
No, not lottery, Lords.
You don't want any more lottery?
No lottery. Only by the spirit of
time-
the,
This time you may be lucky.
no. By the spirit of the notification, they have passed, Lords.
They have filed any affidavit?
Not by the
Depart-
department, by the private respondent, they have filed saying, not by the department as such, Lords.
Department has not filed.
He's fighting this case since 2020, but somehow that has not gone to a logical conclusion, Lordship, as yet, though he has successfully got his.
You have the advantage on the age.
They have the advantage. I do not. I have only 2 years, 2 or 3 years left for the service. Oh, with senior, I'm the senior.
Your age, date of
Yeah.
birth, age.
Yes, Lordship, I do have.
Your
In fact, I
skill is
also
there.
have the qualifying marks advantage, Lordship.
Qualifying marks
If they
advantage.
consider the qualifying marks as
Qualifying marks in which, in what?
maybe B.Ed or maybe MA degree, if they consider to be the qualifying for the post, I'm got the higher marks. So maybe in that zone also I'll be,
Obviously, that's how you build up your case.
yes, Lordship.
Otherwise, why should you ask for a redraw or reconsideration?
Not reconsideration. No more draws, Lordship.
Yes, Mr. Datta, what do you say?
Lordship, on last occasion, Lordship has directed us to produce a record of the selection, whether he was present or he has consented
No,
on.
we have said present.
Let me complete this. Please take your seat and let me complete and you can submit again. And I have Lordship produced that record of the selection.
Where?
Lordship, yes,
This one?
yes, Lordship. Lordship may particularly go to the red flag. That is the report and minutes of meeting, Lordship, conducted on 21st of November 2024, Lordship. That was the report of hearing, Lordship. That hearing was conducted, Lordship, in presence of both the petitioner as well as the private respondent of 4, Lordship. Lordship. And there was, Lordship, another, before going to that, Lordship, there was another flag, yellow flag mark, Lordship, I have. That Lordship will get that attendance sheet of hearing, Lordship.
Hmm.
Lordship, here, Lordship, at CL number 5, he is the petitioner, Lordship.
No,
At
attendance,
CL number 4 is the private respondent.
they have attended.
They have attended, Lordship.
No, thing is that whether they have given consent or
In
not.
their presence, Lordship, एक minute over. In their presence, Lordship, that lottery was done and minus was drawn, Lordship. After that, Lordship, it was on 21st of November. He came to know the result on that day itself. Thereafter, on 3rd of December, Lordship, he filed one representation. That after a gap of 10 days,
The
Lordship,
result was out on which date?
on 21st of November 2024.
Huh?
The report was prepared, Lordship, on that day itself,
The hearing was conducted on which date?
on 21st of November.
So the same day,
Same day, Lordship.
result was out.
In presence of Lordship petitioner and as well as the private respondent for Lordship. How now can he approve it and reapprove it on that his matter, Lordship?
No, 21st of
November to.
November 2024. Then
Then Lordship, on that day, Lordship, result was.
result was out on the same day.
Same day, Lordship, in his, their
No,
presence.
but
Lordship.
you have not, you don't have that written consent, isn't it? That will draw lots, any
Uh,
objection or not?
Yes, specifically no consent was taking that we are consenting.
Hmm.
But in their presence, when they sign, when they present, when they sign attendance, and after drawing their report, they
No.
have signed
Attendance is for being present in the hearing.
present and.
It is
report-
not saying that I consent to the drawing of lots and this is my signature.
That
It's
is
not like that.
nothing, But
Attendance is for the purpose of being present in the
Yes.
hearing.
suppose, Lordship, if he has raised objection on the very next day, that would have been presumption that, yes, he never did consent. But this minutes was drawn in their presence, to which they have consented. Thereafter, can he again reapprove that, Lordship, that we have no consented when the result has gone against him?
No, no, Mr. Datta, see,
I got your point, Lordship.
it is one thing to say that
Yes.
lots was drawn in his presence and they were consenting to that.
Yes,
It is another thing to say that
Yes.
hearing was conducted, they were present, there's attendance sheet.
yes.
So merely giving a signature in the attendance sheet does not demonstrate that he has agreed to it. Okay,
May I just point out one part? Just one point I would like to clarify with regard to the argument. Lordship, that order was given to us on 29/1/2025 in a contempt proceeding. Order was not passed on the same day, Lordship. In fact, though they have passed on 12/12/2024, order copy was not given to us until 21/1/2025 in a contempt proceeding, Lordship. It was given only before this honorable court. Lordship will see the last annexure of my
January,
writ
in
petition.
January.
Lordship, that order was not given to us.
No, you were given in January.
January in a contempt proceeding before this honorable court. The order I have annexed at page 80, Lordship.
Okay, I've understood.
So it is not it may not be, I do not know what instruction he has got, but it is not correct that order was passed on the same day, Lordship.
Okay, I've
In fact,
understood.
we have pleadings, we have also the order clearly states that. We have filed RTA application seeking the order, which was not given even on the RTA application, Lordship.
All right, let him complete.
Yes, I just wanted to clarify that point. It was not passed on the same day, Lordship.
Mr. Datta,
Yes.
you were saying that some representation was given.
Yes,
What is that representation?
Lordship, that representation he has annexed, Lordship.
It's not in your instruction.
No, it is not in my instruction.
Then what is all these papers then?
That paper regarding, Lordship,
Mark sheet and all that?
yes, Lordship, hearing and his present attendance sheet, Lordship, particularly.
You have a second copy with you?
Yes, Lordship.
Photocopy?
Yes, Lordship.
Let us see what has been recorded here regarding the
Lordship, report of hearing, Lordship.
consent or not consent.
Yes. Report of hearing, Lordship.
Hmm.
Lordship, got that report of hearing, Lordship, last page, Lordship. On discrete examination, Lordship, that is pages,
Where?
Lordship, that report of hearing conducted by the State Selection Board, that red flag mark, Lordship.
Paragraph numbers are there.
There
What
is
are
no
these?
paragraph number, Lordship.
Huh?
That report of hearing, Lordship, that flag mark, portion, red flag mark portion, Lordship. Yes, that,
No, red flag mark is there.
yes,
Then
the last page of that report, Lordship. Fourth page. On discrete examination by the state, Lordship, got it? That page start with that sentence.
no, you don't start, you don't read there. I want you to read somewhere where the draw of lots has
Yes,
been.
yes, yes, in that page, Lordship. I'm just drawing your attention to that page. Start with the sentence on discrete examination of the State Selection Board. There is a table, Lordship, also.
You should read from paragraph 21. It is on the third page of the report.
By the
You don't have.
report doc- Sorry, Lordship, I'm not getting, sorry, reported document, my.
I've just marked it with this. Just have a look. You don't have a second copy with you,
No, I have second copy, Lordship.
then just identify that paragraph 21 and read.
Yes, I got that point. Okay. Lordship,
I'm not
paragraph
interested
21,
in the conclusion straight away,
Yes.
Mr. Counsel.
Lordship, that blue flag mark portion, Lordship.
That I know. I'm not interested in that at the moment.
Okay.
You should read from paragraph 21.
Lordship, paragraph 21 is the observation. In view of the read appeal, Lordship. In view of the discussion, we do not find any case for interference with the impugned judgment and order that is so and so passed by a learned single judge in so and so. Hence, the read appeal is dismissed, no cost. A hearing was conducted at the office of the Director of Secondary Education Assam on so and so in connection with the honorable court order dated so and so, passed in so and so, filed by Brian Boy and so and so. Passed in so and so by filed Brian Boy, and the observation of hearing as follows. From the above facts and circumstances and upholding the observation of Honorable High Court, B.Ed degree obtained by Brian Soikia may be considered as valid. Sri Brian Soikia and Brian Bora were awarded same 15 marks in the selection process, and Sri Brian Bora has already been appointed as a regular principal of Kedarhat Senior Secondary School District Lakhimpur on 29/4/2021. Hence, the matter may be placed in the next meeting of the State Selection Board. The matter was placed before the State Selection Board meeting on 23/9/2024, and the board decided to call both the parties for hearing before the State Selection Board in compliance of the Honorable High Court order dated 5/12/23, passed in writ petition number so and so, filed by Brian Soikia, and order dated 23rd April 2024, passed in writ appeal number so and so, filed by Brian Bora. Accordingly, A hearing is conducted by the State Selection Board on 21/11/24, and it is found that Biren Seke and Biren Bora were awarded the same 15 marks in the selection process, and Shri Biren Bora has already been appointed as regular principal of Khezarhat Senior Secondary School, District so-and-so. Fixation of pay was made by the government in respect of Biren Bora by government letter number so-and-so. On risky Selection Board, it is seen that Shri Biren Seke and Biren Bora secured same mark in defined head as follows: leadership skill, administratively so-and-so. Hence, there is no any alternative choice left for the State Selection Board regarding selection of regular principal Khezarhat Senior Secondary School, Lakhimpur. After threadbare discussion and mutual consent of both the petitioners, the State Selection Board decided to arrange a lottery between Biren Seke and Biren Bora. The name of Biren Bora came as a selected in the lottery. Hence, Shri Biren Bora will continue his service as regular principal. This is the position, Lordship.
That's all?
This is Lordship. But so far as Lordship, that's regulation which my learned friend has referred. Lordship, this regulation, these rules is in respect to senior secondary government school service. And this selection were initiated under the Assam Senior Secondary Service Rule 2003, now repealed, Lordship. In that rule, Lordship, I will just draw one attention to rule
2003,
2003 rule,
or post of principal.
post of principal, because it was the selection process commenced on 17/9/2019, Lordship, prior to coming into Act 2018 rule, Lordship.
Now, what is the
And
selection
that-
commenced on which year?
19, Lordship,
2019.
2019, 17/9/2019, that proposal was mooted.
Ah,
So 2003 rule would be applicable, Lordship, as per the repeal clause of 2018 rule. Now this school is governed by Assam, Lordship, Secondary Education Provincial Service Rule 2018.
no, just a minute. Let us be clear about it. You say the selection was initiated in which year?
In this year, Lordship, 2019, Lordship,
2019.
19, Lordship. So I'm giving that, Lordship. The 17/9/2019 proposal from Inspector of School to fill up that post.
And what was the governing, the rules?
At that point of time, Lordship, rule was Assam Secondary Education within bracket Provincialization Service Rule 2003.
Two thousand three.
2003. Rule 13 governs that selection procedure of selection of principal.
This rule has been repealed.
Repeal.
When? By what? By which
By
rule?
Lordship, the rule was repealed on Assam Secondary Education Provincialization of School Service Rule 2018.
Assam Secondary,
Education Provincialized School Service Rule 2018.
Assam Secondary Education Provincialization,
Provincialized School, Lordship.
provincialized,
Yes, Lordship. And this rule came into force.
provincialized schools,
Provincial School Service Rule 2018.
schools, service rules,
Service Rule, Lordship,
2018.
18. And this rule came into force from Gazette Notification, Lordship, 10th of October 2019.
You're saying that the rules of 2003
Has
has been
been repealed.
repealed by these
By
rules of
this rule.
2018.
18. Despite repeal,
Hmm.
it was saved by section Rule 35, Lordship, repeal and saving clause. Where, Lordship, it was mentioned, Lordship, may I read, Lordship?
Yes.
And the Assam Secondary Education Provincialized Service Rule 2003
Hmm.
order or notification corresponding to this rule and in saving force immediately before commencement of this rule are hereby repealed, provided that all order made or action taken under the rules so repealed or under any general order ancillary thereto shall be deemed to have been validly made or taken under the corresponding provision of this rule.
Hmm.
By this clause, Lordship, that selection process is safe under 2003 rule, Lordship.
Okay.
Now, Lordship, anything to be law applied would be on 2003 rule.
Hmm.
And under 2003 rule, rule 13 dealt with procedure of selection of principal of 2003 rule.
Selection has culminated in which year?
2019.
Finalized
Finalization Lordship letter 2021.
by which order?
Lordship that order.
Selecting the private respondent.
Yes, Lordship, that was passed in 29/4/2000.
29/4/2021.
What is that? 29/4/2021?
29/4/20, the private respondent 4 was appointed as a regular principal of that
Page
concerned school.
44 would be Lordship, that order.
Page 44.
It's a type copy of the order.
Thereafter, Lordship litigation start.
Litigation was prior to that also.
No, what you're saying, Mr. Datta,
Lordship,
is that initiation of the selection process started
Lordship,
on 17/9/2019.
19,
Then at that time, the rules of 2003
prevailed.
was
prevail,
prevailing.
Lordship,
Ultimately, it was repealed with effect from 10/10/2019
Lordship,
by the rules of 2018.
Lordship,
But in view of the saving clause,
Lordship.
whatever was done under the old rules
It will be-
remains.
Remain, Lordship.
Now, question is, under the old rules, you say Rule 13 is the
Rule
rule.
13 deal with that procedure.
Where do we get Rule 13? Let us
Yes.
see
It upon second.
this book,
This book, Lordship.
page number.
Lordship, my book में page number 377. Assam Secondary Education Provincial Book.
Please read.
Lordship. Lordship got it?
Yes.
Procedure of selection of principal. 1. Before the end of each year, the member secretary of the school selection committee shall invite application from the intending eligible candidate through an advertisement to be published at least 2 widely circulated local newspaper. On receipt of application from the eligible candidate, the school selection committee constituted under Rule 8(4), after scrutiny of the application, shall hold an interview and prepare a panel of 3 candidates on the basis of quality of such as leadership skill, administrative ability, integrity, and commanding personality. This is important, Lordship. I will come. The panel of names so prepared by the school selection committee shall be forwarded through the concerned inspector of school to the state selection board constituted under Rule 16 for approval. After receipt of the panel under Sub-Rule 3, the state selection board shall prepare a select list equal to the number of vacant posts, taking into consideration such as leadership skill, administrative ability, integrity, and commanding personality. The panel of names so prepared and recommended by the state selection board shall be submitted to the government, which may, after causing such verification as may be deemed necessary, shall record approval for appointment. The select list so prepared and approved shall be in force for 1 year from the date of approval of the government, provided that if the school selection committee fails to prepare panel of name under Sub-Rule 2 within 6 months from the date of vacancy arise, the state selection board shall make selection and prepare a panel of name following the procedure so and so. This is not. So, Lordship,
Mr. Datta, one thing is there, the manner in which selection is to be done is provided therein.
yes, Lordship.
But does it foresee any situation when both parties are equal marks?
No, that rule
So
is
that
silent.
is, that is silent.
Yes.
You don't get that in 2003
Yes.
rules, and
Or-
perhaps you don't get in 2019
19
rules
rules,
also.
18 rules.
18 rules also is not there.
Not there, Lordship. Lordship is correct,
So under that situation, what is to be done? One option is that draw of lots.
Lordship.
The other option is that rules of 2000.
23, that guiding principle, which
Guiding-
my learned
Uh-huh.
council has been
So
drawing.
which one is to be adopted? That is the question.
Yes, yes, Lordship is correct. Lordship, in this case, my submission was that in some cases, Lordship,
Hmm.
being a council of APSC also, what we are preferring in Assam Public Service Commission, that marks obtained the candidate in the written test,
Hmm.
if there is a written test. And if not, if all marks is also equal, then the who is age in superior in age, he would be given selection in that situation, Lordship. It is in aspect of preparing the merit list, the seniority in the merit position, Lordship. But this is not that case. The difference between that, there is only one post. The selection committee will have to recommend only one post, Lordship, against the name of 3 panel of candidate, Lordship. And the criteria of selection, Lordship, which that leadership skill, administrative ability, integrity, and commanding personality.
So see, everything is equal.
All are equal in so far as marks, Lordship. Then in some cases, Lordship,
No,
some
see,
judgment,
the kind of assessment done,
Lordship,
there are 1, 2, 3, 4, 5.
five head,
There are 5 criteria.
five criteria, Lordship,
And in all the criteria, they're getting equal marks.
equal mark. Then that tie breaking, in order to tie breaking the procedure, whether it would be the drop lot or some other procedure is to be evolved by the selection committee. This is the question we are answering from this court, Lordship. Because when the rule is prescribing some certain procedure, we will have to go by that. But when rule is silenced, in Jammu and Kashmir High Court, Lordship, we have filed today morning, they have divested the power to the selection committee to adopt a methodology in consonance with the Article 14 of the Constitution of India. What would be the best methodology to select out of that 2 candidates? Honorable Jammu Kashmir High Court Lordship left the discussion to the selection committee. If Lordship at the end of the day hold that drop lot is illegal, then matter may be relegated to the selection committee to evolve a procedure in consonance with the law.
We agreeable to that, Lordship.
I am just making submission. No, actually, let me
Hmm.
complete.
That is why you all are here. If everyone
I'm not-
agrees, then nobody will come
I
here.
am not concluding, Lordship. I am just giving some of my thought, Lordship, in this case.
Yes.
So, drop lot was, when both are equal, we have not distinguished, Lordship, both are equally suitable. So who would be pick up? What would be the criteria? When the both candidates were found suitable at par, Lordship, and if both were present in the hearing, they were called especially by the state selection committee, they were present, and in their presence, drop lot were held. Thereafter, whether they can now restricted from that.
Only one
situation,
thing, one question is that draw of lot was done.
Lordship.
How long does it take for drawing lots? 1 second, 5 seconds?
That instruction I don't have now.
No, just generally you just apply your mind.
Lordship.
If draw of lots, you go for a cricket match.
Yes,
Who will bat first? Who will ball first?
just.
They draw lots.
Yes.
Do they wait for 10 days?
No.
After 10 days, we'll tell you what is the result.
No, he was,
Immediately they have to play. So out here also, draw lots is not secret, isn't it?
yeah, no.
Parties were present according to you.
Lordship,
Parties were present.
Lordship.
So why didn't you say that, okay, now heads and tails, you have chosen heads and it turned out to be heads. So the person who has
Yes, yes,
taken head, Mr. Bora, he's the one who will get the thing.
Lordship.
So immediately they should have known.
No,
But see, he's saying that they did not know about this result. It only came to light in the month of January when he filed contempt.
it is his submission. His submission,
That is his submission,
Yes.
correct?
his submission.
So
because,
what is your response to that?
+4, sub+4.
Because immediately after this
No,
draw of lots, they
Lordship,
should have said that now parties are hurt. They have agreed to drawing of lots. And after drawing lots, we found that Mr. A is the person who is successful. So accordingly, we recommend Mr. A to be appointed.
Lordship, that.
That should have been there.
Yes, yes, that state level selection committee is not the appointing authority, Lordship.
No, not the appointing authority, but the results of the lot should have been there.
Kindly come to +4.
So
I am
This-
troubling, Lordship. +4,
clause 4 of what?
that rule 13. Sub rule 4.
No, there's no dispute about
No,
that.
that he is,
Selections
was
committee
testing.
duty is to recommend.
yes, yes,
Appointing authority is different else.
yes.
They'll look at the thing, if they
That
accept
order
that
was-
appoint.
That order was issued only on that day, Lordship.
No, the result has to be known
No,
also.
result on that day in
Or
their
you will,
presence.
you will keep the result in that ballot box,
No, in their
secret
presence.
ballot.
Lordship, in their presence, results were declared, Lordship. In their presence. Thereafter, only after taking formalities, before taking formalities, Lordship, that matter has to be routed for defined department, defined table, Lordship.
No, see, in the meeting,
So,
in
Lordship,
in
may
the
I-
hearing, report of hearing, you should have written here that draw of lots was done
Yes.
with the consent of the parties.
Uh,
And after the drawing the lots, it turned out that so and so, Mr. Bora has won the toss.
Lordship.
So accordingly, the selection committee decides to forward his name
Yes, Lordship.
before the competent authority for issuing the consequential order.
Yes, sir. Now,
Something like that. It is not there.
No,
Only on 12/12 the order was passed. After 20 days.
I'm
21 is the hearing date,
That's
order
why,
date is
Lordship.
12/12 Lordship.
Lordship, that's why, Lordship, I'm just,
The order was
I just
12/12.
pray before Lordship to have a look again, rule 4, Lordship, of sub-rule 4 of 13.
If they reject on leadership quality or any other qualities, they can write that down in a order, not in a lottery. The clause that he's referring to is the quality of the candidature, Lordship. That I may be rejected on that ground.
Lots,
Clause 4, sub-clause 4, Lordship, of rule, sub-rule 4 of rule 13, Lordship.
read,
After receipt of panel of sub-rule 3, the state selection board shall prepare a select list equal to the number of vacant posts, taking into consideration of such leadership issues so and so. The panel of names so prepared and recommended by the state selection committee shall be submitted to the government, which may, after causing such verification as may deem fit, shall accord approval for appointment. So this process, Lordship,
that's what I just said. You're
Yes.
repeating what I said.
Lordship, that for that process, Lordship, there may be some time
Select-
required.
Selection committee does not issue appointment order. Nobody is issue that. They'll
No.
just recommend.
Lordship, that is, they have
And
recommended,
especially even if it's the Assam Public Service Commission also,
Lordship,
government is not bound to accept that.
no,
They may not agree with that
Lordship, correct,
by giving the reasons, no, we don't accept the recommendation.
Lordship,
They may differ.
yes.
So that is
for-
why they cannot issue the appointment order. They
Yes.
are only the body which gives the selection thing. Similarly, as per these rules, the committee will just make a selection.
Lo-
Only surprising thing which I pointed out already is that if draw of lots was done with the consent of the parties, you should have mentioned there that we have drawn the lots and it turns out that Mr. A has won the toss.
No,
But
that
since
was,
we are only the selection committee, they will take a decision on that.
yes,
Draw of lots was held in presence of all the parties. He was present, myself was present, and also director and commissioner. It was
When did you know the result?
same day, when that lottery happened, Lordship, in front of the parties, Lordship, the director was asked to pick up one seat, and director picked up the seat of Biren Bora.
Let us see your affidavit, your file affidavit.
Yes, yes.
Where did you state that? Same day I came to know.
Maybe Lordship, yes,
Tell me.
Lordship, after he finished, Lordship,
No, just now you tell me. I don't think the detailed hearing is required on this issue. Para 5. Has agreed to proceed to the process of lottery held during the hearing in the office chamber of secretary, wherein DSC Assam was also present. And when the result came out against him, he has now turned around by saying that he has not given consent.
the director was asked to pick up one seat, and in presence of, Lordship, the commissioners, this director, and both of us were present. In presence of us, Lordship, this lottery was held.
No, presence is
Nothing.
something else. See,
So you cannot say that he was not present.
No.
I never said that.
no, the result came out on the same day and all of us were informed.
5 second, third.
That is not stated here. That's
Yes.
why. You are all repeating what I'm saying.
Lordship, my learned friend has told me that they have filed, they have sent their affidavit for vetting. That Lordship, if the affidavit comes, Lordship, maybe part of that stand is there.
No, the records are here. So what affidavit cannot be beyond the records.
Then Lordship, I may be allowed to argue my.
Yes. Mr. Datta, I think you have completed.
Lordship,
Let him
that part,
argue.
that part.
We'll complete this matter. I'll give you 5 minutes.
Lordship, first of all, Lordship, I have been a regularly selected candidate and I am protected by Article 311(2). I will have to be given a so called, Lordship. I am a regularly selected candidate. There is no fault on my of mine. Because in
If you
2019,
take up that argument, have you
Yes.
challenged the order passed by the single judge?
yes, in the REIT appeal.
Then what is the outcome?
Yes, Lordship, the REIT
What
appeal,
is the outcome?
that REIT appeal order was upheld by the division bench.
Then after that, what did you do?
Lordship, Lordship, may kindly hear me.
Further appeal? No.
No. Lordship, the writ petition was entirely upon his Lordship validity of his B.Ed degree. Because when he obtained his B.Ed degree from Bipura P.T. Golas in 1996-97, there was no NCT approval.
We cannot open that
And-
subject now.
Yes, I am coming.
So three affidavits were filed, NCT, director and secondary, that his BEd degree is not valid. The entire litigations of this 2019 and 20, that was with only with regard to validity of the BEd degree of the Biren Soiker. Lordship, the selection between the petitioner and the respondent, that was not gone into by this honorable court. And my appointment has never been interfered by this honorable court. Because I am a regularly selected candidate.
No, that's correct. But the
Yeah.
thing is that a rehearing was directed to be done.
Yes, rehearing was done. That is why, Lordship, I was also called for a hearing.
Court
Now,
did
now,
court did
Lordship,
not directly interfere with your appointment, but said rehearing should be done.
yes,
You were not happy with that, you went in appeal.
Lord-
The appellate court also found nothing wrong in that.
Yes.
So that matter has attained its finality.
and Lordship, the
So
particular,
now today, how can you say that unless 311 is observed, I cannot be removed from my post?
because
How can you say that?
because those aspects were not gone into, the merit aspect was not gone into, only with regard to validity of his BEd degree, that was adjudicated by this honorable court. And Lordship, secondly, Lordship, the rule my learned friend has shown, that is pertaining to, Lordship, Assam Secondary Education Government School Service Amendment Rules 2023, which pertains to, Lordship, I have given a details in page 91, paragraph 21, which pertains to entry-level vacancy position of the post of graduate teachers, postgraduate teachers, including subject teacher in vocational subjects at entry level, Lordship. If the two candidates is given obtain equal marks, then only, Lordship, this amendment rules is applicable. But here in respect of principal, Lordship, the selection is the criteria among the merits, and seniority has nothing to do with. And Lordship, if Lordship, they would have taken a criteria, Lordship, may kindly take my Lordship affidavit in opposition. I have given a chart, Lordship. If the qualifying marks of the examination, because I am a subject teacher of maths and he is a subject teacher of English, that comparative assessment, Lordship, can be done, can be seen from
Page?
page 93, Lordship. Because subsequent selection is done by a YFA notification, Lordship, in respect of the percentage of marks in the qualifying examination. Biren Soikia in degree examination, he has obtained 43.45 and I have obtained 53.87. In postgraduate, he has secured second class below 55. I have secured first class 61.30. And he is teaching English, that is average 40%. And Lordship, only in BEd examination, he has scored over me.
No,
But-
what is the last column? Pass
Last
percentage.
Lordship, because he is a subject teacher of English, the percentage of students passing out is 40%.
And in your case?
In your case, I am the principal, Lordship. I didn't need to teach, Lordship.
Pass percentage
Yes.
of the college
College,
in the subject of English.
subject of English.
You were
And Lordship,
already,
only in Lordship, BEd, Lordship, he has scored over me, but BEd, he has passed
just a minute,
Lordship.
this assessment was done for which particular period?
overall
You were not principal from day one.
Lordship,
You were also one of the candidate for the principal
Lordship,
and you were teaching in maths.
maths.
What is the pass percentage for maths?
That instruction immediately I don't have, Lordship.
Your column is empty, that's why you're saying
Yes,
that I'm principal.
Because I am a principal, that is
Your
why.
principal later on after your appointment,
Yes.
29/4/2021.
Before
Before that, you were teaching maths.
that I was teaching maths. I
So,
was appointed as the principal
the
in
pass
2000.
percentage should have been there.
Yes, 106.
Anyway, so
Only in BEd, Lordship, he has scored over me, but BEd, Lordship, he has passed
Yeah.
in compartmental examination.
Hmm.
And in the first year in 1996-97, he failed.
Hmm.
Then second time he has passed, but I have passed my BEd examination at one go.
Hmm.
So there cannot be a comparison between a compartmental pass candidate and a regularly passed candidate.
where is that statement?
Yes, Lordship. Page 92, Lordship. Page 92, the claim of the petitioner to appoint him on the basis of BEd mark is not tenable. It is reiterated here that the petitioner was admitted in Vipuria. Lordship, may skip it. The petitioner reappeared for BEd examination held in July 1998. The result of the examination was announced on 27/2/1999 and he had passed the examination in second attempt. First year he filed, the petitioner also failed in the same examination, 97 he failed. Then he passed in 99. But on the other hand, the respondent number had passed B.Ed at one go. And as such, there cannot be a comparison of marks between a compartmental pass candidate and a regular pass candidate. So even if the authority would have considered the qualifying marks, the marks of the qualifying examination, that is, let's say, the subject, because we are both subject teachers, he is a subject teacher of English and Maths, the comparison, Lordship, I have scored better. And since 2020, Lordship, I have been working as a regular principal. I have been given the scale of principal also. And in the earlier round of litigation, Lordship, this merit aspects were never gone into. Only with regard to his validity of B.Ed degree, that was adjudicated. Lordship.
Okay. That's it.
So even if I take into consideration the argument advanced by my learned counsel, I'm agreeable to any other method than the lottery, even considering the percentage of past percentage or any other arguments he has made.
Okay.
Only not the lottery. Lordship.
Okay, we'll close the matter. Heart, Mr.
My name is D. Deka, Lordship.
D. Deka,
Yes.
learned counsel for the petitioner. Mr. P.P. Datta, learned standing counsel, Secondary Education Department, appearing for respondent numbers
1, 2, 3 would be.
1, 2, and 3. And Mr.
SK Das.
SK
For
Das.
respondent number 4.
learned counsel for respondent number 4. Stop. Having regard to the nature of the grievance projected by the petitioner and the issue involved, the writ petition is taken up for disposal. Stop. Next para. The writ petitioner earlier approached this court by filing WPC number 2057 of 2020. On being aggrieved with the non-acceptance of his B.Ed degree for being considered for the post of principal. Principal of which college? Which school? Name of your school?
Kheras Khat Senior Secondary School. Kheras Khat.
Okay, principal. Kheraj Khat Senior Secondary School,
Yes, Lordship. Lord Lakhimpur.
not Lakhimpur.
Yes.
Stop. The writ petition came to be disposed of by order dated 3/12/2020 in favor of the writ petitioner with the finding that his B.Ed degree should be taken into account for considering his appointment to the post of principal of the said school. Stop. The present respondent number 4 was also arrayed as respondent number 6 in that writ petition.
7.
6, 7 is NCT.
Lordship, 6. 7 in
6.
written. 7 in written.
I think there's some mistake in the order also.
It's showing 7, Lordship. Even up. Page 47 is the, Lordship will see page 7. 47, number
No.
7 is B.N. Bora.
See, the course title at page 41. Number 6 is B.N. Bora. Number 7 is NCT.
So it is that is, Lordship has referred to two different writ petition. 2057 was filed in 2020. What was decided in 3166, that page 46, Lordship. The cost title of page 46 is the writ petition which was decided, Lordship. The number was, there's two different orders which was
No, what was the earlier writ petition then?
page 46, Lordship.
No, what is page 40? Page 40?
Page 40 is another writ petition where we file with the similar prayer, which was remanded back to the NCT to consider my validity of my as a petitioner's BA degree.
Then,
NCT has considered and they remanded back to the secondary education department of government of Assam to decide on my BA degree. They again held it to be invalid. On that, subsequently, we filed that writ petition number 3166 2021, which was decided, Lords. The similar prayer in the entire, all the writ petition, it was
so
similar.
what did I say? Before that. Sentence, beginning of the sentence, outside. No, before that also. Okay, that you cancel, huh? Had case number.
316.
Had earlier opposed this court by filing what is the case number?
46.
WPC number 3166
Yes, Lord.
of 2021, which came to be disposed of by judgment and order dated 5/12/2023. Then he continue. What did I say after that? Oh, no. I think you cancelled that. I'll give you again. All getting confused. Writ petition earlier opposed this court by filing with WPC number 3166 of 2021, which came to be disposed of on 5/12/2023 in favor of the writ petitioner. Stop. The writ petitioner was aggrieved in respect of his B.Ed degree not being accepted for the post of principal of the school concerned. This court, therefore, this court came to the finding that the B.Ed degree of the petitioner should be taken into account for considering his appointment to the post of principal. To stop, the present respondent number 4 or 3?
4, Lords.
Respondent number 4 was also arrayed as respondent number 7 in that writ petition. And this court taking into account the fact that the respondent number 4, no, the respondent number 7 had already been appointed to the post in question, directed the respondent authorities concerned to give due opportunity of hearing to him before taking a final decision. Stop. Next para. Aggrieved. The respondent number 7 filed writ appeal number 9 of 2024. But the judgment and order of the learned single judge came to be upheld by the division bench by judgment and order dated 23/4/2024. Stop. Following the disposal of the writ appeal, The State Selection Board conducted a hearing in terms of the direction of the learned single judge, which was upheld by the division bench. To stop, the hearing was conducted on 10/6/2024, 23/9/2024, and finally on 21/11/2024. On 21/11/2024, as consented by the rival parties, lots, a lottery was drawn, by which the respondent number 4 came to be selected for the post inspector. Stop, agree with the same. The writ petitioner has filed the instant writ petition. Next matter, the learned counsel for the petitioner submits that the writ petitioner, although present in the on the day of hearing, never gave his consent for drawing of lots. And therefore, the arrangement of drawing of lots is totally unacceptable to the petitioner. The learned counsel submits that when the marks are equal amongst the candidates being considered, the respondent authorities ought to have adopted other procedure except the drawing of lots. Stop, in this connection, the learned counsel submits that as per the Assam Secondary Education, open bracket, government schools, close bracket, service, open bracket, amendment, close bracket, rules 2023. It is provided that when two or more candidates obtain equal marks in aggregate, the candidate getting comparatively high marks in B.Ed examination will be preferred. And if the candidates have equal marks, even in that situation, then the seniority of age has to be preferred. Stop, he therefore submits that the procedure adopted by the selection committee should be interfered with by this court with a further direction to adopt any other procedure as may be permissible in law. Next para, Mr. P.P. Datta, in terms of the last court's order, has produced the relevant records and he submits that the parties concerned, in fact, had agreed to the drawing of lots and it was therefore carried out. Mustafa, he submits that the selection committee had devised a method for breaking the tie, since both the candidates had secured equal marks in all the different heads devised by the selection committee. Stop. Therefore, as the process of selection for the post of principal was on the basis of merit, the device, the procedure adopted by the selection board cannot be faulted with, particularly when the parties had agreed to the drawing of lots.
There is no malafide also on the part of election board. There is no malafide alleged in against that election board also.
Stop. He also submits that there is no malafide alleged against the selection board. And under the circumstance, the writ petition should be dismissed. Stop. Next para, adopting the submission made by Mr. P.P. Datta, Mr. S.K. Das, Learned Counsel for Respondent number 4, submits that the respondent number 4 and the petitioner were present on the date of hearing. And it was agreed upon that the issue be settled by drawing of lots. And therefore, the said procedure was adopted. Full stop. However, the petitioner, upon coming to learn that the draw of lots ended against him, he has now once again approached this court challenging the said process. Which he had agreed at the time of hearing. And therefore, the same cannot be allowed to stop. He submits that the competent authority is empowered to decide the method to break the tie. And since the selection was on the basis of merit as well, the procedure adopted cannot be faulted with. To stop, the learned counsel further submits that even on merit, the respondent number 4 is more meritorious, having scored higher percentage in the degree examination. To stop, he further submits that while the respondent number 4 cleared the B.Ed exams at one go, the writ petitioner had cleared the same examination in his second attempt. Now, therefore, even on that count, the respondent number 4 has clear advantage over the writ petitioner. To stop, he submits that the respondent number 4 has been appointed on 29/4/2021, and he has been enjoying the pay scale of the principal of the school since then. And therefore, he cannot be deprived of the post except by due process known to law. Stop. Under this circumstance, the learned counsel submits that the writ petition does not have any merit and the same should be dismissed. Next para, I've heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the records produced by Mr. P.P. Datta.
Also, may I point out one thing? Because I have also, he relied upon the rules lordship that is only pertaining to government school, which is not relevant in the case. Because we have a different set of rules lordship, Assam Second Education Provincial Service Rules 2018. The rule he has preferred lordship, that is not applicable in this case lordship. In paragraph 21 lordship.
The rule he refers
Yes,
to is
91.
with regard to persuasive value with regard to the breaking a tie, not the rules for recruitment also.
Okay, we'll add that anyway.
We also submitted it only for the persuasive value also, because they are already known to the methodology to break a tie.
Page 91, paragraph 21.
Before that, I have heard the submissions. Now you add this. Page 91.
Page 91, paragraph 21.
The learned counsel for respondent number 4 also submits that the rules of 2023 referred to by the writ petitioner is not applicable to the instant case What have you stated here? Please tell me.
Yes. Lordship, he referred the rule of Assam Secondary Education Government School Service Amendment Rules 2023.
Why is it
wherein
not
if-
applicable?
If a two candidate is obtains the same mark, then Lordship, the B.Ed mark should be considered. That is only pertaining to entry level qualification of graduate teacher. Entry level and that too in government school. But our is a provincialized school, Lordship, the different rule is applicable, Lordship.
In view of the fact that the said rules is only uh, meant for
Government school,
government schools at the entry level,
Lordship,
whereas the college
Lordship.
Provincialized.
Provincialized,
in the present case is a provincialized college,
Lordship. Senior secondary school.
is a provincialized senior secondary school. Okay. I've heard the submissions, so and so, so and so, okay. What is the last sentence? Including the records produced by so and so. That much. Stop. From the projection made by the rebel parties, the issue to be decided is as to whether the drawing of lots can be considered to be an acceptable procedure for breaking the tie. Full stop. The records produced by Mr. P.P. Datta has been perused, wherein it is seen that the State Selection Board, which held its meeting on 21/11/2024, on discrete examination under different heads, found the writ petitioner as well as the respondent number 4 to have scored exactly the same marks, not only in the total, but under the different heads that has been devised. Full stop. It was under such circumstance that the board thought it fit to go for drawing of lots after having the mutual consent of both the parties. Full stop. Although the report of the hearing provides that after threadbare discussion and mutual consent of both the parties, the State Selection Board decided to arrange a lottery between the two contenders. There is no material brought to the notice of the court to show that a written consent was obtained from the parties concerned. Mr. P.P. Datta has drawn the attention of this court to the signature appended by the writ petitioner as well as the respondent number 4 on 21/11/2024. But it is seen that the same is a signature appended in the attendance sheet, and which does not, which necessarily cannot be understood as consent given by the parties for drawing of the lots. Stop. It is no doubt true that a selection committee or for that matter, a selection board, in absence of any provision provided in that regard, can devise a method for breaking the tie. But however, in the present case, unlike a selection procedure wherein the candidates have not participated, hearing was conducted in terms of the direction passed by this court, wherein it was mandatory for the parties to be heard. The parties were present on 21/11/2024. But not but, and as per the report, a decision was taken by drawing lots with the mutual consent of the parties. Stop. It is, however, seen that what was the result of the drawing of lots has not been recorded in the report. And according to the writ petitioner, the result came to be known to him only after he had filed contempt case C number
371,
371 of 2020
2024.
24,
Filed the contempt before, disposed of after the order was passed by placing that order.
24, where what was produced?
The order was given at the page 80, annexure 12.
Which order?
Page 80, annexure 12, Lordship.
One correction,
Just a minute, Page 80.
On that day, order was given to us, a copy.
Which order was given to you?
The order 12, the order which is under challenge. That is the order where the decision of the lottery was declared, Lordship.
On which date? The impugn order dated
12/12/2024.
12/12/2024 was given to him.
Until then, we are unaware of the results.
Stop. Therefore, having regard to the manner in which lots was drawn, This court is of the view that the same was adopted without the pre-consent of the writ petitioner. And accordingly, the impugn order dated 12/12/2024 is found to be unsustainable and is set aside. Stop. This court is also of the considered view that in the absence of any specific provision prescribed under the rules governing the selection to the post of principal for the school concerned, the staff selection board would be at liberty to devise its own method, which should be guided by fairness and which should be any other means excepting the drawing of lots. Yes, you were saying something?
And Lordship has mentioned that in the report, the result of lot was not mentioned.
Hmm.
But there was a minute, the name of Birendra came as selected in the lottery. It is mentioned. That blue highlighted, blue flag mark. Last but third paragraph, the name of Birendra came as selected in the lottery.
Okay.
And in page 66, he also stated in his representation, the Anderson and Chief Bora also remain present.
I was present, Lordship. I all along maintained it.
Anyway, I'll adjust that. I'll make the necessary correction. Uh, The staff selection board shall therefore undertake a fresh exercise to consider and select to undertake the selection process
Yes.
afresh. Hearing will not be required now.
Not, it is already decided. Marks are already before the board, Lordship.
uh, and come to its conclusion uh, as expeditious as possible. And at any rate, within a period of 1 month from the date of receipt of a certified copy of this order. The decision to be arrived at by the selection board, staff selection board. No, cancel that. The appointment of the respondent number 4 shall be governed by the decision to be arrived at by the staff selection board. With the above observation direction, the petition stands disposed of. I'll make some
Yes, yes.
few rectifications here and there.
State selection.
State selection board.
Since your lordship has referred the matter before the state selection board, your lordship may can also indicate one, there is a guidelines now, lordship. At page 111.
What is that guidelines?
26/12/2018. Page 111. No, move it. Move it, affidavit.
No, that freedom they'll be giving. We're not
Yes,
indicating.
yes.
If I indicate it again,
Yes.
same problem will come. Some leverage they should have, but
Yes, yes, sir.
only thing is that because of the claim of not having the consent, that is the only thing which is bothering the court. Yes, anyway.
Obliged.
Otherwise for 5 minutes. This was writing number. Five minutes. I'm done.
May I be the lordship? The case of the petitioner is that the petitioner is a retired employee. During from the education department, during his service period, he was suspended for 2 times. And by the interference of this honorable court, his suspension was reinstated. But the period of suspension is not yet regularized, for which lordship he has received the low amount of pension. That is the case, lordship. In this case, lordship, on 29/8/2025, instruction was called for from the BTC department. BTC.
Happy to Lordship. Lordship, in this matter, we have received the instruction. Lordship, some time may be given for us to bring on record or stand by way of an affidavit. We have received the instruction recently, Lordship. We'll bring it on record.
When?
Lordship, in 2 weeks' time.
Okay. Your good name?
N.R. Sharma,
Mr. N.R. Sharma, learned counsel appearing for
BTC.
respondent BTC submits that he has received the instructions and prays for 2 weeks' time to file the counter affidavit. Prayers allowed.
Mr. Kindly fix a date, lordship.
List again on so and so.
And
Operators.
90.
May I please?
Yes.
Here the petitioner is similarly situated with item number 7 also, my lord. Here the petitioners are 4th grade employees, grade 3 and 4th employees of various higher secondary, senior secondary and high schools, my lord.
Yes. You're covered by what? Mohar Ali Sheikh.
Covered by the judgment on passed on 5/8/2025 by the Honorable Division Bench in writ petition number 3239/23. A group of writ petition. There were 4 writ petitions, my lord. And after them, there are several writ petition has also been disposed of by the Honorable single judge, single bench,
No, you just tell me one writ petition. Which one? Page 121.
my lord.
Which case is that?
Yeah, here it is, my lord. Page writ petition number 3239/23.
What was the direction?
The direction was to consider their matter within 8 weeks, my lord.
What was the finding? Tell me before that.
May I read it, my lord?
Yes.
The
What are the petitioners? They are the senior assistant, junior assistant, library assistant, And
And-
grade 4?
Yes, my lord.
Okay. In different senior secondary, higher secondary and high schools?
Yes, my lord.
Okay. What was the decision? Tell me.
The findings in judgment, page number 287, my lord.
Hmm.
Paragraph number 15, under the Act 2017, the tutors, the relevant paragraph is accordingly the present batch of writ petitions.
No,
stands
no, no.
allowed
You
by-
read from 15.
My lord.
You
Under
were
the,
reading paragraph 15.
yes, my lord.
Please continue reading that.
Under the Act 2017, the tutors were provided fixed scale of pay till the acquisition of their qualification to recognized upgrade as teacher. However, as recorded here in our above, it was held by the coordinate bench that when the services of those tutors were considered and the same were brought under the government fold, a regular scale of pay was to be given to them. Therefore, we are also of the opinion that the same principle of law shall be applicable in the case of non-teaching staff whose services though had been provincialized and were brought under the government fold but were paid a fixed scale of pay. However, what should be such scale of pay should be left to the wisdom of the state.
Mm.
Accordingly, the present batch of writ petitions stands allowed by holding that the non-teaching staff would be entitled to equal treatment under the law as is extended to other government employees by virtue of their acquired status as employees of the state of Assam, and since the other employees are enjoying the benefits of regular scale of pay, they should be paid a just scale of pay. However, what should be a just scale of pay is neither a question raised before this court, nor we are inclined to enter into the said aspect of the matter in these writ petitions ordered accordingly. The determination of such scale of pay shall be made within a period of 8 weeks from the date when a certified copy of this order is submitted before the competent authority in education department by the petitioners. This disposes the writ petition parties to be given.
The writ petition was filed challenging some provision.
Yes, my lord.
What was that provision?
6(1).
What does it say? What does 6(1) say? Shall get fixed pay. Then what happened to this?
My lord.
What happened to that provision? Has it been set aside?
Yes.
Uh,
Section, the services of teachers in a Bhansar educational institution from the primary level up to the degree level shall be considered for provincialization in the post of teachers or relevant teaching faculty in appropriate nomenclature as the case may be, subject to the fulfillment of the eligibility or criteria relating to educational institution provincial profitable. The Assam extra. Then
Six my lord, page 93. Section 6. Assam Education Provincialization of Services Non-Teaching Staff of Bhansar Educational Institution Act 2018.
Mohar Ali Sheikh. What was the direction? Tutors will be entitled to enjoy benefit of regular scale of pay that they have been extended to other employees of the state. So this is covered by Mohar Ali Sheikh's judgment. Isn't it?
yes, my lord.
Apart from this case you have just referred to, what is that?
Abdul Motleb, my lord.
What is the lead case? Abdul Motleb.
Yes, my lord. Case number 3239/23.
Mr. Sharma,
My lord.
This appears to be a covered case.
My lord, in this matter, I got the information that similarly situated person is instituted a writ petition, and my lord, the state has upon judgment that the state has filed a review petition in that matter.
What is the outcome of the review?
No, review is still pending, my lord.
Okay, so the same submission was made in Abdul Matleb's case also.
So notice is issued in that matter, my lord.
Maybe.
Yes.
See, regarding the pendency of review, that was also the review in Mohar Ali Sheikh.
Yes, my lord.
Yes.
Not
Mohar
in this case, my lord.
So there is no outcome till now.
No, my lord.
So unless there is an outcome, the Mohar Ali Sheikh holds the field,
Yes.
isn't it? Even that Mohar Ali Sheikh's case was mentioned in this Abdul Matleb's case.
Yes.
DB Division Bench has said that no, you have to give them the pay scale. Determine the scale. How much you have to give them, it's up to you to determine. 4 weeks, 6 weeks time was given.
4 weeks.
8 weeks.
8 weeks, I'm sorry. 8 weeks of time was given. So we'll dispose it of in similar lines. You can verify very well, do whatever you have to do. But they were earlier, they were getting how much? What were they getting?
8,000 and 10,000.
Fixed pay.
Yes, my lord.
The school was at the venture stage,
Yes, my lord.
subsequently provincialized.
Yes, my lord.
After provincialization, you have been paid fixed pay.
Yes, my lord.
Your demand is that you should get pay scale,
Yes, like
scale
other.
of pay, like others.
Yes, my lord.
Well.
So we are disposing of, what is your name?
S.U. Ahmed.
Heard Mr. S.U. Ahmed, learned counsel for the petitioners, and Mr. U. Sharma, learned standing counsel,
For the respondent authorities, secondary.
Secondary Education Department for all.
Second.
Lordship, I'm for respondent number 5.
Yeah, BPC also included, so I am for the respondent number.
1 to 4. 1 to 4.
For the
Yes.
Secondary Education
One.
Department, and Mr.
Two.
N.R. Sharma. N.R. Sharma.
MR,
N.
NR, and Mr. NR Sharma, learned counsel for respondent number
5.
5. Also heard Miss so and so for the respondent number. RM Barua, SC Finance. Who else? That's all.
My lord, in 5986/2025, here is only 3 respondent, my lord. One is the state of Assam represented by Commissioner and Secretary to the Government of Assam. Second is Commissioner and Secretary to the Government in Assam, and
Okay,
third is
okay.
Director of Secondary Education.
Don't worry about that. RM Barua for respondent number 3. Okay. U Sharma is for 1, 2,
3.
and 4. 1, 2, and 4. U Sharma for 1, 2, and 4. Then RM Barua for number 3. Then that VTC Council for number 5. The facts of the case has already been highlighted in the earlier order of this court dated 24/10/2025. And for the sake of brevity, the same is being abstracted here under. Just abstract this order. Okay. The learned counsel for the petitioner submits that after disposal of the case of Mohar Ali Sheikh and others, Supra. A few other cases on the same issue came up for consideration before the division bench of this court. And the lead case being WPC number 3239 of 2023. Abdul Motleb and others versus State of Assam and others, close bracket. And they were disposed of by common order dated 5/8/2025. In line with the decision rendered in Mohar Ali Sheikh and others, Supra. By directing the respondent authorities to determine the scale of pay payable to the petitioners within a period of 8 weeks. To stop, the learned counsel therefore submits that a similar order may be passed in this case, since the present case is clearly covered by that decision as well. Next para, Mr. U. Sharma, on being asked as to what is the outcome of the review petition that has been preferred in Mohar Ali Sheikh and others. Supra submits that the same is still pending as on today. Next para, upon considering the submissions made by the learned counsels for the rival parties and upon perusal of the materials available on the court, this court finds that the present case is clearly covered by Mohar Ali Sheikh and others, Supra, as well as by the case of Abdul Motleb and others, Supra. Stop accordingly, the writ petition stands disposed of by directing the respondent authorities concerned to determine the pay scale that may be payable to the petitioners within a period of 8 weeks from the date of receipt of certified copy of this order. The petition stands disposed of. You just call item number 7 of.
My lord, in the item number 7, the petitioners are only grade 4 employees of upper primary schools.
Yes. Art Mr. S.
Yes.
U. Ahmed, learned counsel for the petitioners. Miss
And Fukan,
N. Fugan, learned standing counsel.
elementary.
Your elementary, isn't it?
Yes, ma'am.
Elementary education department.
Respondent 1, 2, and 4.
Hearing for respondent numbers
1, 2, and 4 number.
1, 2, and 4. Miss Aram Barrow for respondent number 3. They are only what?
They
Grade
are
four?
only the grade 4 employees, my lord, upper primary schools. There is no grade 3. Yeah.
Okay. The learned counsel for the petitioners submits that the petitioners are grade 4 employees.
Yes, ma'am.
Working, where
In
are you
various
working?
upper primary schools.
Working in various upper primary schools in the state of Assam. So he submits that the schools where they are working were initially at the venture stage, but they were subsequently provincialized. Full stop. However, despite provincialization of their service, they have only been given fixed pay and not scale of pay. First off, the learned counsel submits that the case of the petitioners is squarely covered by the decision rendered by coordinate bench of this court in Mohar Ali Sheikh and others versus State of Assam and others, 2024, 5 GLT 689, wherein the respondent authorities were directed to determine the scale of pay admissible to the petitioners therein within a time frame. To stop, he submits that in terms of the decision rendered in Mohar Ali Sheikh and others, Supra, few other writ petitions had been filed before this court. And they were all disposed of by a common order dated 5/8/2025, with the lead case being WPC number 3239 of 2023, bracket Abdul Mutlib and others versus State of Assam and others. The learned counsel therefore submits that the instant writ petition may be disposed of in similar lines.
But my lord, review is pending.
Next para, Ms. N. Phugat, learned standing counsel. On the other hand, submits that a review petition has been filed against the direction of this court in Mohar Ali Sheikh and other Supra. And since the outcome of the review petition is awaited, the petitioner cannot claim that their case is covered. Stop, next para. It may, however, be seen that when the case of Abdul Mutlib and others, Supra, was taken up, a similar submission was made. And the division bench of this court, despite such submission, disposed of the writ petition in line with the decision rendered in Mohar Ali Sheikh and others, Supra. It is submitted at the bar that the review petition is not yet disposed of till date. And in the event of, and therefore in the event of such pendency, the same cannot be construed as a bar for depriving the instant petitioners the benefit of having a similar order. Accordingly, the writ petition disposed of in terms of the decision rendered in Mohar Ali Sheikh and others, and Abdul Mutlib and others, Supra, by directing the respondent authorities to determine the scale of pay admissible to the petitioners within a period of 8 weeks from the date of receipt of a certified copy of the bounty.
Review petition number 15/25.
Time being 20 of the supply list.
None appears for the applicant when the matter is called. List again after 2 weeks. You write one thing, none appears for the applicant when the matter is called for the second time. That's VC approved, so we'll go with that.
So, my lords, basically, this is if my loss will recollect on the last date of hearing. I had moved in a stay application also, and the other side had sought time to file a reply, and liberty was given to me to file rejoinder to their affidavit in opposition, which I have done, my lords. Now, my lords, there are two applications listed today before my lords. One is IA Civil 168, my lords, in the disposed of writ 80 of 2022, and my lords, IA number 195, which is for the stay, my lords. And my lords had last time put a query to me that after passing the direction and the order on 8th March, my lords have become a functus officio. Is this application maintainable or can be maintained, and appropriate orders can be passed? I'll try and satisfy my lords on the maintainability, jurisdiction, and whether I am entitled to a relief or not, my lords. This is based on the supported by the precedents of the Honorable Supreme Court on the various counts. That I'll try and make good, my lords. So I'll take my lords, the modification application, my lords. First is 168, my modification application, my lords.
Yes.
So, my lords, after this honorable court passed the order on 8th March 2024, there were three remedies available to me, my lords, basically.
Yes.
One was, my lords, an appeal. Second was, my lords, a review. Third was, my lords, to go to the existing tribunal today, which is seized of the arbitration. And, my lords, none of these remedies are now applicable or available to me as an alternate relief. Therefore, my lords, I had to invoke the jurisdiction of my lords under 151. And I'll make good why none of these remedies, alternate remedies are available to me. In appeal, my lords, if my lords has para 18 of my lords order, I'll just go to that because it's I had agreed and consented, and I have basically there is no dispute. First, my lords, I had consented and agreed.
Regarding 151, you mentioned, you are talking
Yes,
about
ma'am.
CPC.
Yes, my lords.
151 CPC.
Yes, my lords. 151.
Inherent power.
Yes, inherent power, my lords.
Okay.
So, my lords, as I said, my lords, I had three options after my lords gave a direction on 8th March 2024 that the retention money be kept in a fixed deposit subject to the adjudication of the rights between the contractor and the subcontractor by the arbitral tribunal seized of the matter at that point of time.
Yes.
There has been subsequent event, which I'll my lords, substantiate and elaborate in detail shortly. So, my lords, none of what I was saying was none of these options, neither appeal, review, or going to the existing tribunal.
Yes,
Who
Mr.
is
Roy, you have said that already. Don't repeat
Yeah.
again. You have already
Yes,
said,
my
I've understood.
yes, my
Now,
lord.
you were referring to some paragraphs of the order passed by this. court.
Yes, my lords. So, if my lords has page 40 of my application, my lords.
40.
Yes, my lords.
Yes.
Para 18, if I may be permitted to read, my lords.
Yes.
It may, however, be seen that so far as the employer is concerned, there is no dispute as regards the amount to be disbursed either to the contractor or to the subcontractor. The dispute or controversy is how much of the retention money should go either of the parties, the petitioner or the respondent number 4, or whether the entire amount should be released exclusively to one of the parties to the exclusion of the other. This court has been informed that the respondent number 4 has opted for arbitration, and the arbitral tribunal comprising of 3 arbitrators in the midst of considering the dispute, and dates have been chalked out for recording of the evidence starting from 11th March 2024. Therefore, Millers, I did, because there was no dispute, so I consented I will release as per the adjudication order, Millers. So, Millers, I could not have preferred an appeal because I almost, as this quasi consent given. Second, there was no dispute in that writ petition vis-a-vis the employer, Millers. Therefore, there is no opportunity for me to file an appeal, Millers, against this order. Because of the subsequent development, which I could have justified to the appellate court, because of the subsequent development, my position has been substantially altered. That I'll make good, Millers. Second was, Millers, can I file a review? No, Millers, because the grounds for review is only, Millers, discovery of the new fact. There is no discovery of the new fact, Millers. This fact was not there before my loss. That's a sine qua non for a review. This was only a subsequent development, Millers, a subsequent event. So therefore, I could not have preferred a review also, Millers. Third, Millers, I can't go before the existing tribunal today asking for any kind of protection in case my counterclaims are allowed, because the tribunal will say there's already an order of this honorable court and they cannot. There's order of this honorable court for release of the amount, and they cannot overreach or overturn the order of the honorable court. So these are the 3 remedies, Millers, available to me, which I can't exercise, Millers, today, as of now. So the Millers, the only option today, the available remedy to me is to invoke the jurisdiction of this honorable court under 151. In order to see that no prejudice or undue hardship was occasioned to the employer. Otherwise, I have no option. Now, Millers, having said that, Millers, and whether this application is maintainable, whether my lords have a power after giving a direction, I'll just simply read out and I'll take my lords through the judgment of the Honorable Supreme Court in the state of Punjab. It says, Millers, such a decree may be modified prospectively if the circumstances, whether of fact or law, on which the decree is based are substantially altered. So therefore, Millers, what I'm trying to submit, Millers, respectfully submits, the fact or law. The fact was there was no arbitration between me and the contractor at that point of time, Millers. There was no claim, which has been subsequently altered, Millers. Now, after they waited for this order of my lords for retention money, and then they invoked arbitration, Millers. So it was a misrepresentation, I would construe, and I will make good that, Millers, because misrepresentation is a ground to modify the order. And this has been said in Ajanta by the Honorable Supreme Court. And the mistake also, Millers, because the contractor had never raised any final bill. Had they raised the final bill as per the contract in terms of clause 57, and if they had a claim, they would have raised it because it had to be settled. There was no claim. So when my lords were seized of the matter, there was no claim. And they took the order and direction from this honorable court for release of retention money. And thereafter, subsequently, they have invoked arbitration and lost the claim of 377 crore. And this has substantially altered my position, which is on fact, Millers, and on law also, Millers, which the Supreme Court said. So, Millers, I'll straight take my lords through. I'll take my lords through my first judgment. I need to satisfy my lords on the law first, then on the merits. Merits, I don't think this. So, Millers, if my lords has a judgment, which I have filed yesterday, Millers, which is on page 107, Millers. 107, State of Punjab, Supreme Court, Millers. 2004, 12 SCC 673. State of Haryana versus State of Punjab, Millers.
Just a minute. Give me that file. Yes.
So, Millers, has my lord got that judgment, Millers?
Yes, I've got it.
Yes. So, Millers, if my laws can come to para 37, Millers, which is on page 124, Millers. Has my lord got that?
Just, yes, 124. I've got
Para
it.
37. I'm reading. Can I, may I read Miller's para 37?
Yes, read.
The plaintiff in the present case claims that the legal right in question is the right to have an injunction modified by reason of changed circumstances. Several decisions, both Indian and the United States, have been cited in support of this proposition. Before we consider these authorities, it must be kept in mind that as far as this country is concerned, the general law relating to injunction is contained in Section 36 to Section 42 of the Specific Relief Act 1963. Although these provisions may not limit the powers of this court under Article 133, nevertheless, they provide valuable guidance as to the nature of this form of equitable relief. An injunction may be permanent, perpetual, or temporary. A permanent injunction is final and conclusive of the facts in the context of which the injunction is granted. A temporary injunction, by contrast, is granted on a prima facie view of the fact, and as the word temporary itself indicates, is an interim order pending final adjudication of the rights of the parties. This distinction is not to be confused with the distinction between a prohibitory or preventive injunction on the one hand and a mandatory injunction on the other. So I'm placing my reliance on the prohibitory and preemptory injunction, Milos, which I'll make good. Why this order and the prayer that's sought for in the writ. In the first case, a party is prevented from doing a particular thing or continuing with a particular action. A mandatory injunction, on the other hand, commands an act to be done as provided for under Section 39 of the Specific Relief Act 1963, which reads as, I will not bother my lords now with a relevant paragraph, other paragraphs, which are fact. If my lords can straight come to para 50, my lords, on page, which is 128, my lords. Various principles have been laid down in the preceding paragraphs. It says 50. May I read, Milas?
Yes.
It says the principle that emerges from these decisions are that there is a distinction between a final preemptory injunction and a final decree which requires a continuous course of action. B, a decree granting a preventive injunction continuously operates to prevent a course of action. And C, that's where I'm relying upon. Such a decree may be modified prospectively if the circumstances, whether of fact or law, on which the decree is based are substantially altered. That's where, because subsequent events, Milos, in my case, has substantially altered my position. This one, Milos. And Milos, I don't want to further bother my loss with this judgment. The second judgment, Milos, which I refer and rely upon, is of Ajanta, Milos, which is on page 143. This is also Supreme Court, Milos.
Yes.
If my lords can come to page 153. And I would like the liberty of this honorable court to read para 21 and 22,
Yes,
Milos. 21 and 22, Milos.
You may read.
Yes, Milos. A judgment by consent is intended to stop litigation between the parties just as much as the judgment resulting from a decision of the court at the end of the long drawn out fight. A compromise decree creates an estoppel by the judgment. It is relevant to note that in Brahim, Pestonji, Gariwala, this court has held that the appellant therein did not raise any doubt as to the validity or genuineness of the compromise, nor was a case made out by him to show that the decree was vitiated by fraud or misrepresentation. While stating so, this court dismissed the appeal. Next important, Milos, where my emphasis is. A consent decree would not serve as an estoppel where the compromise was vitiated by fraud, misrepresentation, or mistake. Milos, that's very important. That's where I'm going to lay my emphasis on. The the court, in exercise of its inherent power, may rectify the consent decree to ensure that it is free from clerical or arithmetical errors so as to bring its conformity with the terms of the compromise. Undoubtedly, the court can entertain an application under section 151 CPC for alteration, modification of the consent decree if the same is vitiated by fraud, misrepresentation, or misunderstanding. That's where I'm coming now, my submission is vis-a-vis misrepresentation, Milas. So it was on a misrepresentation, Milas, that I had consented to. The reason for misrepresentation was, Milas, there was no final bill submitted by the opposite party number 1 as mandated by clause 57.1. Had they submitted their final bill, reconciled accounts, Milas, and there was any claim of the opposite party number 1 or the contractor, I would have, Milas, with all due respect, not agreed to this arrangement. Secondly, Milas, misrepresentation was, Milas, they did not raise or invoke the arbitration at that point of time. The reason was, Milas, they waited for the retention money order to be passed by this honorable court because of their precarious financial health, Milas. As my laws are aware, must have, right from day one, they have been not in a sound financial head to execute the project. That's how the subcontractor executed the total project in totality. That is the reason I've invoked the jurisdiction, Milas. Milas, because I can't be left remediless. And if my counterclaims, which is for the post-submission of the bill and for the defect liability period, I have incurred around 5 crore, Milas, for completing the work, I can't be left, Milas, in the high and dry, Milas, if that is allowed. So that's why misrepresentation I have done, Milas. Second is a mistake. Milas, it was a mistake that there is no claim by both. Had there been a claim, Milas, if I was given to understand, I understood, Milas, there was a presumption. There was a presumption that there is no claim by them, and I agreed to for release of the retention money. That's it, Milas. So it was misrepresentation. They waited for this. They invoked the arbitration. They have not raised the final bill. And as per the Milas retention money, this will only be released after, as per clause 32 Milas, only after the defect liability period is over. And when they had come to this honorable court for release of the retention money, Milas, the defect liability period was still subsisting in terms of clause 32 Milas. So it was, and because they did not rectify the defects, so I had to undertake and appoint a third party to complete the work. Those are my claims, Milas, which I am legally entitled to recover from them. I don't want to get into the merits, Milas, because that. So, Milas, it was basically mistake. Therefore, Milas, this court has the power to modify prospectively any order which has substantially altered my position and which is because of the law and fact which existed at that point of time. The whole dispute was, Milas, between basically contractor and the subcontractor. There was no dispute vis-a-vis me. There was no claim vis-a-vis me, Milas, at that point of time. Therefore, Milas, I had consented that whatever is subject to the final adjudication of the rights by the tribunal, I would release the money, Milas. Milas, third judgment, Milas, is whether my laws can pass in order. Exercising jurisdiction under 226, yes, Milas. I'll take my lots to the first judgment of the Supreme Court. These are the 3 judgments, Milas, which is on Odisha Forest, Milas. Page, Milas, 86. This is of Justice Bhanumati and Justice Rishikesh Roy, Milas. This is Odisha Forest. If my laws can turn over to para 19, Milas, which is on page 102, Milas. 101. It starts from 101. May I read, Milas? 19 to 23 is important, Milas. My last will bear with me. I just need to read this. 90. In that regard, it is noticed that in the instance case, in a circumstances where the private respondent had filed the writ petition, even though the High Court had permitted the process of retender to progress the finalization thereof, has been stayed. If that be the position, the appellant herein was not in a position to immediately bring the Kendu leaves for re-auction by receiving the amount from the subsequent purchaser, and the same is likely to have dissuaded the purchaser to offer the best price due to uncertainty looming large. Whether all this and any other factor has caused the loss to the appellant and the public exchequer is a matter to be determined based on materials and evidence, but the fact remains that such resultant delay was not at the instance of the private respondent. As noticed from the terms of the agreement, any loss cost was permissible to be recovered from the respondent after adjusting the security deposit available. I'm emphasizing on this, Milos. Therefore, even if the amount of deposit made pursuant to the order passed by the High Court is not considered as an additional security deposit, the rights of the appellant to proceed in accordance with the law to assess the damage suffered and to recover the same from the private respondent would still remain intact. As such, the deposit order will have to be considered as a conditional deposit to protect the interest of the appellant. In such event, the issue for consideration is as to whether, in view of the clause contained in clause 9 subclause 4 of the tender notification, the appellant should be driven to initiate the legal proceeding or for public demand recovery after refunding the amount which is deposited as contended by the learned advocate for the private respondent, despite taking note of the intent of such deposit. It is no doubt true the writ proceeding initiated by the private respondent, and in the absence of such deposit, option in any event was open to the appellant to make the recovery through such proceeding. It is noticed that apart from the right available to recover the amount by forfeiting the additional security deposit, the appellant had also clearly indicated that the subsequent sale would be made at the risk and cost also of the private respondent herein, which would mean that the difference of the cost between the first and the second auction and the resultant loss to the appellant, if attributable to the private respondent, is recoverable from the private respondent. However, it is no doubt true that such recovery is to be made after qualifying the same by following the due process of law. This is important. Next para. Presently, though the learned senior advocate for the appellant has furnished a chart showing the original price as against the resale price, thereby projecting the net loss suffered by the appellant, the correctness of the same cannot be adjudicated in a proceeding of the present nature arising out of a writ proceeding. The matter being contractual and also requiring factual determination, the same can only be done in an appropriate proceeding. In my case, it is pending, Milos. Therefore, though at this stage the said amount of deposited as ordered by the High Court cannot be considered as an additional security deposit, nor the actual determination of the loss suffered when in a circumstances the action of the appellant to retender was caused to be deferred through a proceeding initiated at the instance of the private respondent, the condition to deposit the amount should have been considered by the High Court in the background of its intent to protect the interest of the appellant. In that circumstances, when the contention of loss being caused was put forth, the amount ought to have been allowed to be retained till the procedure as contemplated in law is followed and decision is taken, though not directly as forfeiture. As noticed above, para 22, Milos, the appellant in any event would have the right to determine the loss suffered and recover the same in accordance with the law, as the process to retender was at the risk and cost of the private respondent as stated in the notice of determination. In that circumstances, when it is a prima facie indicated that due to the delay caused at the instance of the private respondent, the value of the Kendu leaves has reduced, thereby causing loss in view of legal proceeding initiated by the private respondent. The court will have to bear in mind that the maxim actus curiae neminem gravitas, namely no party should suffer due to the act of the court. In such event, since the interim order was at the instance of the respondent and the appellant should be, in our opinion, be permitted to retain the amount and complete the process by providing opportunity to the private respondent. In the above circumstances, the direction to refund, this is important, In the above circumstance, direction to refer the amount unconditionally is not found justified and is accordingly set aside. The appellant shall issue appropriate notice to the private respondent indicating details about the manner in which they computed the loss after conducting the second auction at the cost and risk of the private respondent. On receiving the response to the same, a detailed consideration be made and speaking order be passed in that regard. The respondent are at liberty to challenge the speaking order to be passed by the appellant and the process being pursuant to a contractual matter, and the private respondent, if aggrieved, are entitled to avail of all the legal remedy before the appropriate forum in accordance with the law, and entitlement of the amount will be decided therein. As per the speaking order passed by the appellant, it is found that the loss suffered is within the amount available in deposit. Appropriate adjustments should be made and the balance, if any, be refunded. On the other hand, if the loss cost is found to be more than the amount in deposit, the amount available shall be adjusted and the appellant would have
All
to
right, Mr. Roy.
Yes, Milas. So,
What
Milas,
are
this
the-
court. So, what I'm
Please
saying,
listen.
Milas, I have a entitlement to recover these amounts under
Please
the
listen.
contract. Yes.
Please listen. What is the order that you're seeking from this court now?
I am only saying, Milas, let this amount, which is 25% of the retention money, be kept in a fixed deposit, Milas, subject to the outcome of the arbitral proceeding, which has been initiated by the opposite party
Between you and
and the subcontract and the contractor.
contractor. That
That's
is,
opposite party number 1, JK. That is all I'm seeking, Milos. I'm willing to comply with my lord's direction. That's all. I am totally willing to comply. I have no problem, Milos. I just want, Milos, that because of the precarious financial health, Milos, tomorrow, and it's on the record, without any rebuttal, Milos, I have incurred more than 10 crores, Milos, to complete the project. They have, it was subcontractor, as my laws are aware in the order. They have executed the whole project. They don't have financial health to satisfy any decree or award, Milas.
you are for the applicant, isn't it? You are for,
Yes, Milas.
you're for the department.
Yes, Milas.
This amount of money which is still pending,
Yes, Milas.
this is towards
Retention money, Milas.
retention money.
Yes, Milas.
This is to be given to either of the parties, isn't it?
Yes, Milas.
The
Milas,
contractor or the subcontractor?
the subcontractor have already paid, Milas, because there is no privity of contract between me. The division was, Milas, the retention money was to
You
be
paid
this.
75% of the amount.
Yes, Milas, because there is no privity of
Remaining
contract
balance is
between.
25%.
Yes, Milas.
This has to be paid to whom?
This has to be paid to the contractor, Milas. 25% has to be paid to the contractor, the opposite party number 1.
Okay, then why are you, you're for the department.
Right, Milas.
The employer, my lord.
So
Right.
this money is meant for the subcontractor.
No, Milas, this is for the contractor, Milas.
For the
Subcontractor.
contractor.
Yes, Milas.
So what sort of dispute do we have with the
Yes.
contractor now?
Contractor has invoked an arbitration, Milas, after this order on 19 September 2024, raising a claim of 377 crore on me. I have also filed my counterclaim, Milas, and my counterclaim number 3 and 4, if my laws want me to take through, is post the DLP period because they did not rectify, and I have incurred 10 crore, Milas. So this dispute was not before my loss when they had approached the courts. So this amount pertains to the contractor, Milos, and they've invoked arbitration post the passing of my loss directions.
All right, so let me hear the other side.
My lord.
Please, Milos.
My lordships, I appear for the respondent contractor.
Yes.
Now, my lords, but giving a brief outline and going into my submissions, my lords, what is the case of the employer today? That, my lords, through an application filed under section 151 of CPC, modify the directions, clear and ambiguous directions given by this honorable court in writ petition, that may be modified. Now, my lords, before I go to the scope, your lordships may kindly come to certain paras of this, of your lordships' directions, which was passed in the writ petition and the stand of the department, my lords.
Yes.
If your lordships may have.
Which para?
My lords, from para 15 onwards, if I may take your lordships. Your lordships has it.
Yes.
I have heard the submissions made by the learned counsels for the rival parties, and I've perused the materials available on record. As may be noticed, out of the two prayers made by the petitioner, what remains to be considered is the release of half of the total amount of retention money, which is retained by the employer. There is no dispute to the fact that the work has been completed and the defect liability is also over. Under the facts and circumstances and as per agreement signed between the employer and the petitioner, the retention money has to be released to the contractor. However, it is also an admitted position that the petitioner had not executed the entire work and in fact has entered into a subcontract with the respondent number 4 as permissible under the agreement dated so and so. It is the contention of the respondents that the respondent number 4 performed the contract work from 0.00 kilometers to 30 kilometers stretch, which comes to 75% of the work. My lords, respondent number 4, as your lordship said, is the subcontractor. And from 30 kilometers onwards up to 41.530 kilometers, the petitioner was required to submit a detailed program to the employer. Since the same was not done, a notice in the form of email dated 23rd January 2020 was sent to the petitioner asking the petitioner to submit a detailed program for works beyond 30 kilometers by 3rd February 2020, and failing which, respondent number 4 will be engaged for the work and payment will be made directly to the respondent number 4 as per the agreement in the MOU signed between the petitioner and the respondent number 4. The petitioner having failed to submit the program for work beyond 30 kilometers, the work is said to have been executed by the respondent number 4 in which they have received payment only for 91% of the work done in terms of the MOU, and after deductions were made towards retention money, pleadings to this effect can be seen from the affidavit filed by the respondent number 4. Now, your lordships, in this para 15, one thing is clear. The employer stance was only with regard to the issue of proportion of payment. They do admit that the retention money, since the defect liability period is over, which comes clear in para 16 of your lordship's judgment. If I may read, my lords, para 16. While such is the position, respondent number 3 on 27th July 2022 had written to the petitioner enclosing a list of damaged pavement and permanent structures along with the CC road as per verification conducted by the senior assistant engineer. Therefore, as per clause 35 of the contract agreement, petitioner was instructed to rectify the damages within the extended period of defect liability period. If the defects were not rectified, the respondent number 3 put the petitioner to notice that clause 36.1 of the contract agreement will be enforced. Further, petitioner has also placed reliance upon the communication dated 30th April 2023, written by the respondent number 3 to the petitioner, informing that the defect liability period ended on 31st March 2023. My lords, I'll stop here. My lords, the whole purpose of retention money is so that, my lords, once the defect liability period has ended and a particular milestone has also been reached in the middle of the execution of the project, the same has to be released to the contractor. That is in the general clauses of contract, but I will not get into that. I'm only apprising your lordships that the stand which was taken before your lordships in the writ petition was that we as the employer, PWD, would release this amount. The only issue was that either we release it 75%, 25%, 50 or so and forth between the contractor and subcontractor. That was the only stand taken. Today, through this application, my lords, they have taken a U-turn and they have sought to, my lords, alter your lordship's clear and unambiguous direction that payment has to be made subject to the arbitration proceedings, which have now culminated. And my lords, your lordships may come to, my lords, the arbitral award, which is at, my lords, it starts at page 42 of the application. Page 42.
Yes.
Yes. Page 42. My lords, this is the arbitration proceedings, the award which has been now issued between me and the subcontractor. Now, my lords, I'll take your lordship straight to the relevant part. Your lordships may kindly have, my lords, para 9.
Page?
page 47. In light of the settlement as above, and this award made accordingly in the arbitration, the parties are directed to approach the employer PWD, Government of Mizoram, for releasing the retention amounts lying in bank deposits as per the direction of the Honorable High Court of Guwahati Aizawl Bench in writ petitions Civil 80 of 2022, JKM Infra versus State of Mizoram. As and when the parties approach the PWD in that regard, 75% of the amount available in the bank deposit on the date of closure of the account may be released to the APS by crediting in the following bank account. Now, my lords, I'll stop here. My only point is, my lords, today an arbitration award has been given, has been issued, taking note of your lordship's direction in the writ petition. If your lordships were to entertain this application, grant the reliefs as sought for, it would have a direct cascading effect, directly interfering with the award, my lords, which would be judicially untenable, my lords. This application, my lords, has been, my lords, filed with a different intention altogether, and it is, my lords,
Yes.
totally untenable, my lords, unsustainable application. Now, my lords, I'll take your lordship straight to the scope of an application under section 151. Because, my lords, the application under section 151 as filed by the employer today is beyond the scope as what has been prayed for, my lords. If I may just share my screen, my lords.
Section 151.
Yes, my lords.
I have it.
Yes, my lords.
I have it with me.
Yes, my lords. My lords, I'll be sharing some judgments. If I may just give your lordships the relevant citation. I'm trying to share it through online, but there's some issue, my lords. My lords, if your lordships may have 2022,
Yes.
volume 19,
Hmm.
SCC 806.
This is regarding?
My lords, the scope of section 151, my lords. CPC. What is the scope, my lords? And my lords,
Yes.
in this judgment, I'm specifically relying on para 27, 28, 33 to 36. Yes, my lords. If I may read one paragraph of this judgment, my lords. I'm sorry, my lords, I should have taken some advance action to
Can
get
you
this.
the judgment? Yes, okay.
If I may read.
You may read.
My lord. Para 27 of the judgment says, my lords, in exercising powers under section 151 CPC, it cannot be said that the civil courts can exercise substantive jurisdiction to unsettle already decided issues. A court having jurisdiction over the relevant subject matter has the power to decide and may come either to a right or wrong conclusion. Even if a wrong conclusion is arrived at or an incorrect decree is passed by the jurisdictional court, the same is binding on the parties until it is set aside by an appellate court or through other remedies provided in law. Now, my lords, I'll stop here. Today, your lordships, the list between the list in the writ petition was only with regard to the retention money, and your lordships may kindly have my counter affidavit. I would just like to show what was the stand of the department then. If your lordships may have my affidavit in opposition, my lords.
Yes, which para?
My lords, if your lordships may have page 6. We've, yes, my lords. Page 6, we have reproduced the stand of the PWD therein, my lords.
Yes.
If I may read para 13, my lords. That with regard to the statements made in paragraph number 12 of the writ petition, I say that both the main contractor, JKM Infra Projects Limited, and subcontractor, APS Hydro Private Limited, have requested PIU PWD not to release any payment to the other party. However, the project cannot be put indefinitely on hold because of the dispute between the main and subcontractor. For closure of the project, retention money and securities being held by PIU PWD will have to be released. They themselves say, my lords. And today they're taking a U-turn through this application. However, as payment ratio is being challenged by the main contractor and expect 100% payment to them, which is in contrast to the MOU dated 21st October 2017 submitted by JKM Infra Projects Limited by their letter number dated so-and-so, PWD had no other alternative but to request settlement between the parties by operating an escrow account where payment can be divided between the parties based on their mutual agreement. Para 14, my lords, that the money retained with PWD has to be released in the ratio 9:91, as this money is being retained from the work done certified in the MOU between the main contractor JKM and subcontractor APS Hydro dated so-and-so. Clause 110 states, in case APS leaves the work incomplete due to any reasons which come under the scope of APS, the retention money available with JKM shall be forfeited by JKM. Since APS has performed the work till completion of the project and even beyond 30 km, retention money has to be released in the ratio 9:91 between the main contractor and subcontractor respectively. That JKM Infra Projects Limited is delaying release of the retention money with claims other than the conditions laid down in MOU dated so-and-so and filing of this writ petition. My lords, we've also annexed with our affidavit in opposition.
This
Yes.
9:91,
Yes,
9 is the yourself,
my lords, correct.
91 is the other subcontractor, isn't it?
Yes, yes, my lords, correct.
But then subsequently, as per the arbitral agreement or arbitral award,
Yes,
you are to divide is in the ratio of 75:25.
correct, correct. my lords.
Hmm.
That is correct. So
Okay.
my lords, on that, insofar as the proportion, that is a separate issue. Now we've consented to a consensual settlement decree.
Yes.
Now the act of the PWD, my lords, I have to point out before your lordships, because post the issuance of the arbitral award, they themselves have admitted before your lordships that 75% of the amount has been paid to the subcontractor. Now, my lords, how can you partly execute an award and at the same time, my lords, say that I'm not going to execute this, the other part? That too, my lords, when your lordships clear directions have already been given. So, my lords, this is the issue. These are the facts before your lordships. And if I may just take your lordships to certain paragraphs of affidavit in opposition. Because
Yes, which other paragraph?
yes, my lords. If your lordships may have, para 16 at page 10.
Yes.
My lords, para 16.1, I may read onwards.
Yes.
A bare perusal of the counterclaims raised in these arbitration proceedings will reveal that all pertain to events prior to completion of the project on 30th July 2021, my lords. That is in regard to the arbitration between me, the contractor, and PWD. 16.2. As such, the applicant was very well aware and duty bound to disclose any complaints or grievances against the respondent in its counter affidavit filed 14 months later on 20th September 2022. My lords, we've given a chart of the satisfactory completion certificate given and the counter affidavit which was filed by the applicant in the writ proceedings. Thereafter, my lords, even it's at para 16.3, even the arbitration proceedings between the applicant and the respondent commenced on 6 June 2024 when the notice invoking arbitration was issued by the respondent. The arbitral tribunal conducted its first hearing on 28th August 2024. The respondent filed its counterclaims way back on 7th February 2025. Yet, at no point of time was any such application preferred before this Honorable Court. My lords, Application meaning the application filed today under 151.
Yeah.
And we've given this chart, my lords, in the next to show the timeline. Arbitration was invoked. Thereafter, my lords, first hearing, the PWD filed its counterclaims before the arbitral tribunal 15 months after the commencement of arbitration and more than 7 months after filing counterclaim. They've come up with this instant application, my lords. And why specifically 15th September, my lords? Before, my lords, the filing of the instant application, if I may continue, my lords.
Yes, it's
We had issued, my lords, a letter stating that you please execute the arbitral award as you have done insofar as APS Hydro and release us the remaining 25% with the interest accrued thereon. My lords, we had no response thereto. Then we filed another letter thereafter stating that we would avail of our legal remedies in law if such execution is not done. Immediately as we had filed the second letter, my lords, this application has come up. So, my lords, it is not that the arbitration proceedings have just been initiated and now the PWD is in a far off, lesser, worse off condition than it was. It is just trying to, my lords, put at bay our relief of what we are claiming, the remaining retention monies. And as your lordships, I have cited the judgment of 2022. Your lordships, section 151 cannot be expanded so much in a way that the whole subject matter of dispute is also expanded, which was not a part of the same in the original writ proceedings, my lords. So, my lords, I would not refer to the contractual clauses. That is a matter pending before the arbitral tribunal. And lastly, my lords, I would like to state a few things insofar as the judgments which were referred to by the other side, my lords.
yes.
My lords, the first judgment, which was the main judgment on which they trusted their point, was, my lords, Odisha Forest Development.
Hmm.
Yes, my lords. If your
Yeah.
lordship sees out here, my lords, a judgment is an authority for what it decides, my lords. A judgment cannot be simply applied by looking at certain facts of that particular case and apply it to any other case, my lords. If I may take your lordships to that judgment, because, my lords, I do not see how they are applicable at all in this particular dispute, my lords. Page 86 of the rejoinder filed by the other side, your lordships has.
Yes.
The judgment starts. And my lords may have para 3 and 5. My lords, just to show the facts. Para 2. The appellant, if I may read, my lords.
Yes, please read.
The appellant, OFDC, issued an e-tender notification dated dated so-and-so, inviting offers online from intending purchasers for advance sale of Phal Kendu leaf of 2017 crop as per the lots indicated in the notification. Private respondent had responded to the notification and made its offer. The bid was opened on 7 December 2016. The private respondent, being the successful bidder, was required to execute an agreement. So, my lords, the successful bidder was required to execute an agreement, deposit the provisional security deposit of rupees 5 lakhs. The private respondent herein executed an agreement dated so-and-so. In terms of the said agreement, on the actual quantity of leaves collected, the additional security deposit covering 25% of the purchase price of the lot was to be deposited before 31st May 2017. The private respondent in the instant case was therefore required to deposit the differential security amount of rupees 27 lakhs so and so less the security amount of rupees 5 lakhs already paid. Now, my lords, at para 3, in view of the requirement to pay the same before the said date, the private respondent addressed a letter dated so and so seeking extension of time to pay the said security amount. The extension sought was declined by the appellant through the communication dated so and so, Now, my lords, I'll stop here and not take your lordships through every detail. This, since the extension of time was delayed, was for seeking extension of time for payment of the security in this case, that was declined by the authorities. That was challenged in the High Court. That is how the list there started, my lords. At para 4, my lords, if your lordship says, at that stage, the private respondent, aggrieved by extension of time not being granted, filed the writ petition in writ petition number so-and-so. The same was withdrawn, and a writ petition bearing writ petition number so-and-so of 2017 was filed, wherein the order dated 21st August 2017 passed by the appellant, cancelling the agreement dated as also the subsequent auction notice were assailed. In the said writ petition, interim order against the subsequent auction through notice dated 22nd August 2017 was sought. While considering the same, the High Court, while allowing the appellant to proceed with the subsequent tender process, had stayed the finalization of the sale subject to the private respondent herein, depositing an amount of rupees 20 lakhs within 1 week with the appellant herein. The said order was passed on 8th September 2017, wherein it was further directed that the said amount would be kept in a separate deposit by the appellant. So, my lords, this is how the case in Odisha, my lords, had culminated. The only issue is that, my lords, if your lordships has para 10, my lords, para 10 of this judgment. I'm sorry, my lords, I'm taking your lordships through the specific paragraphs of this judgment, but this application of the same is highly questionable in our specific circumstance, my lords. Para 10. Yes. The learned senior advocate for the appellant, while contending that the High Court was not justified in ordering the refund, has taken us through the tender notification dated so-and-so, as also the purchase agreement dated so-and-so. In that light, it is pointed out that apart from the earnest money deposit to enable a tenderer to participate in the tender process, the successful purchaser was required to initially pay the provisional security deposit of 5 lakhs. And after final collection of the leaves, the differential amount to the extent of 25% of the purchase price was to be paid within 31st May 2017. It is contended that if the said amount was not paid, the security amount already paid was to be forfeited, and if any further recoveries are to be made, the appellant had the liberty to do so. So, my lords, the whole list was because due to the High Court's judgment order, I had put in certain monies as security deposit. Now, unfortunately for me as a tenderer in those proceedings, there was a forfeiture clause whereby if I take part and I cannot fully satisfy the conditions of contract, that security would be forfeited. So, my lords, there was a specific clause, and the Supreme Court takes note of in this judgment, that had enabled the authorities to, my lords, take back that money, and whatever remained that was not in their right to retain, that was to be released. And in this specific judgment, my lords, I'll end with this insofar as this judgment. Para 16, if your lordship sees, I'm sorry, para, this is para, my lords. Yes, my lords, this is, yes, your lordships may have para 21. I'll end with this insofar as Odisha, my lords. I'm almost concluding my submissions. Para 21. Presently, though the lien, I'm sorry, my lords, your lordship says.
Yes, I have it.
Present.
It was read by the
Yes,
learned counsel for the applicant also.
Yes, my lords.
Anyway, you read.
I'm just reading half of it, my lords. Presently, though the learned senior advocate for the appellant had furnished a chart showing the original price as against the resale price, thereby projecting the net loss suffered by the appellant, the correctness of the same cannot be adjudicated in a proceeding of the present nature arising out of a writ proceeding. The matter being contractual and also requiring factual determination, the same can only be done in an appropriate proceeding. So, my lords, today, this application filed by my learned friend is an extension of the original list, which was in the original writ proceedings, my lords, WPC 80 of 22, which your lordships had given categorical directions. And the list was insofar as only the apportionment of the retention money. And the stand of the PWD I have taken your lordships through. If they have a right to retain this retention money, if at all, that issue is pending before the arbitration proceedings, which are still going on, my lords. So your lordships, in my humble submission, cannot get into that particular aspect of the list today, especially under 151.
Yes.
So, my lords, that is one.
Hmm.
Insofar as Ajanta, which my learned friend had also placed reliance, I'll end with this, my lords. Page 143 is the judgment which they had relied on. And my lords, here, if I may just take your lordships to para 24. Page 154, my lords, rejoinder. Yes. Para 24, my lords, if I may read.
Yes.
The High Court applied its mind and passed a decree in terms of the settlement agreement dated 16/5/2019. Though the High Court dismissed the application by refusing to entertain the application on the ground that it was filed under Section 152 CPC, we have considered the submissions of the parties to examine whether the appellant has made out a case for modification of the decree by treating the application as one under the provisor to Order 23, Rule 1, read with Section 151 CPC. There is no allegation either of fraud or misrepresentation on the part of the respondent. We are unable to agree with the appellant that there was a mistake committed while entering into a settlement agreement due to misunderstanding. Correspondence between the advocates for the parties who are experts in law would show that there is no ambiguity or lack of clarity giving rise to any misunderstanding. Even assuming there is a mistake, a consent decree cannot be modified, altered, unless the mistake is a patent or obvious mistake, or else there is a danger of every consent decree being sought to be altered on the ground of mistake, misunderstanding by a party to the consent decree. So, my lords, today, if your lordships goes through the application filed by my learned friend, there is not a whisper of any such mistake or misrepresentation. In fact, the categorical prayer made by them in their application filed under Section 151 today is seeking clarity and also an auxiliary, my lords, prayer, a term called modification. So, my lords, if your lordships entertains this, it would be, my lords, not tenable at all, my lords.
All right.
I'm grateful, my lords.
All right. I'll
Yeah,
consider-
yeah.
consider-
Milos, there's only one, Milos, if my lords can give me 5 seconds, Milos, 5 seconds. I will not take more than that, Milos, 5 to 10 seconds. Milos, my position in 24 was an induced position, Milos. Say, on the presumption that there is no claim against me. My lords will appreciate when I agreed to the consented order between them, it was an induced position that there is no claim against me. First, Milos. Second, Milos, the pleadings on the induced position cannot work as an estoppel against me because of the subsequent developments, Milos, which my learned friend has not even touched upon. The subsequent development events substantially alters my position, Milos, which has not at all been addressed. Thirdly, Milos, there is a claim 3, 4, and 5, which is post DLP. If my last one I can file, which is almost close to 3.5 crore. It is not during the DLP because they did not rectify it, Milos. If my loss one, I can file those counterclaims before my loss. But I'm making a statement at the bar, Milos. If claim 3, 4, 5 is post DLP. I did not agree because I knew there was no claim. So induced position was this, and you took an order of retention money, then you invoked an arbitration. And this is subsequent event, Milos, which I'm emphasizing on. Had the induced position been clear, if they had raised the final bill, I would have agreed. Now, Milos, only a couple of things, Milos. In my rejoinder, Milos, in para 13, if my loss can just make a note, why I'm justified in retaining the retention, para 13 and 16, Milos, if my loss would consider. Para 13 and 16 of my rejoinder, under clause 48, Milos, I can withhold the retention money and secure the performance. Para 13 and 16, if my laws can just refer to. And second, Milos, my 3 claims are post DLP. Thirdly, Milos, this is very important, which I, because the whole foundation and the trigger point, Milos, for moving this court was not the arbitration, because the crystallization of interstate dispute between the subcontractor and the contractor, Milos. I could not have moved this court not knowing what is the quantum. When the quantum was, it could be 0 and 100 Milos also. Therefore, trigger point was when they asked for. It was not the arbitration which they initiated against me. Because till that time, and most important, Milos, most important, which my lord will take a note, I moved an application before this tribunal for consolidation of both the arbitration proceeding. Right, Milos? The court said this is a mixed question of law and fact. We will do it after the trial. Milos, before that, even the pleadings could be concluded, the contractor and the subcontractor entered into a settlement saying if there is an award in this matter between the employer and the contractor, you give me 10%, I will retain the 90%. That's how they decided, Milos. How the public fund was to be decided once the award is there. So, Milos, they did not even wait for it. I asked for consolidation. Had it been the same case, Milos, this issue would not have come. They opposed it. And the court and the tribunal said, wait. But they entered, before anything could happen, they entered into settlement, Milos. The motive is very clear, Milos, why they entered into a settlement. Secondly, Milos, I'm again making myself clear. There was no claim, Milos, when I agreed, consented to this direction, Milos. It was an induced position, and the subsequent events only, Milos, is the foundation of this application, Milos, which my laws has jurisdiction under 151, because I can't be left remediless and there can't be undue hardship will be occasioned.
All right.
Grateful, Milos. I'm
So I'll consider. And
yes,
ask
Milos.
to say orders.
Grateful.
Very well. Grateful, Milos.
All right, you'll get the order by tomorrow only. I'll be passing the orders in chamber.
Deeply.
Item 8 for hearing.
Miller. No, it's regarding selection and appointment to the post of assistant professor in applied geology, Dibrugarh University. Miller, I take your lordship straight to the advertisement. Annexure A. It is that specialization subject matter. Page 13, Annexure A.
Actually, in fact, this matter was heard. Almost
Earlier.
hearing was completed on the TR. Well, absolutely, it was released from the part of my law.
So I'll be very brief, Miller.
No, you have to satisfy me.
Miller.
Because I've forgotten what you have said out.
Miller.
It was part out for some time, but you know, I fear some place. That's why I released it.
Miller. Annexure A, Miller, page 30. This is the advertisement. And
It's for assistant professor.
professor down below Miller. Miller the C, assistant professor, pay and so, applied geology. Post number 1, reserved for STP, specialization. It is important, Miller. Enter meter, Miller revolves around that specialization word. Specialization geophysics or geostatistics. And next, post number 2, specialization geochemistry, petroleum geology. Lord, kindly, Lord, have a look at that professor post and A and B, my lord. The specialization is open, my lord. Above that C, my lord, A and B, physics specialization open. Then this associate professor, physics specialization open. So, my lord, some posts are, my lord, earmarked for open specialization. And here, my lord, geochemistry and petroleum geology.
So you're stressing on the specialization.
Specialization. Now, kindly turn to page 15, my lord. Detailed information of that advertisement, my lord. As issued by the university authority. My lord, in the middle portion, my lord, assistant professor, minimum qualification and experience. 1. Good academic record with at least 55% marks or an equivalent grade in a point scale, wherever grading system is followed, at the master's degree level in the relevant subject from an Indian university. My lord, the private respondent as well as petitioner, my lord, complied with these, my lord, conforms to this eligibility, my lord, condition 1. 2. Besides fulfilling the above qualifications, the candidate must have cleared the national eligibility test conducted by the UGC CSIR or similar test accredited by the UGC like SLAT, SET or PhD degree under new regulation. 3. NET, SLET, SET shall not be required for such master's programs in disciplines for which NET, SLET, SET is not conducted. So this number 2, the private respondent is having NET, my lord, and the read petitioner is having PhD as well as NET. The essential qualification is master degree with 55% marks. Now, kindly turn to the regulation, my lord, Annexure I, page 28.
Regulation.
For screening and shortlisting. That specialization aspect is my lord,
Regulation.
regulations for screening and shortlisting, page 28, and the relevant portion is at page 29, down below. Screening. A screening committee will shortlist top 15 candidates against the advertised post for each category from amongst the eligible candidates as per UGC, AICTE, NCTE regulations, whichever is relevant for the post advertised in the merit list prepared on the basis of screening criteria detailed herein below. Now, my lord, we can skip other paragraphs, my lord. Page 32. The screening committee, serial number 7. It is very, very important and relevant to the entire matter. There shall be a screening committee entrusted to screen and shortlist the applicants from page 32, my lord.
Yes, I've seen it. Read.
From amongst the eligible applications received from each post of assistant professor advertised by the university. So they will have to screen and shortlist amongst the eligible applications. So that word eligible, my lord, whether private respondent number 6 is eligible or not, my lord. Now the, my lord, marks got by the candidates at page 34.
How many candidates were there?
My lord, total 17. And out of 17, my lord, 7 appeared. The page 34 onwards regarding shortlisting process.
But there are more than 7.
But, my lord, in the interview, my lord, only 7 appeared, my lord.
Who are those? This
Lord,
shortlist
Page
includes, this is before the interview.
before the interview, my lord.
Shortlisting is before the interview.
by the screening committee.
Where is the petitioner? And where is the private respondent?
My lord, next page, page 35,
Serial number?
serial number 5. 13, my lord. Pranjit Kolita,
This is the petitioner.
private respondent number 6.
Okay.
The selected and appointed candidate, my lord. And down below, 16, Dr. Onanya Sutia, the writ petitioner.
Okay.
Both are eligible. And kindly see the, my lord, page 38, my lord. Meeting of the Statutory Selection Committee. Out of 17 candidates, total 7 candidates appeared. Serial number 1, page 38, my lord. Serial number 1, Dr. Onanya Sutia. Total marks 57.31, position 2. Serial number 5, Mr. Pranjit Kolita, the private respondent number 6. He got 59.54 at, my lord, first position, my lord. Serial number 1, Dr. Onanya Sutia, writ petitioner, and serial number 5, Pranjit Kolita, private respondent number 6.
Serial number 2.
The position, my lord, Pranjit Kolita is having first position and Dr. Onanya Sutia, writ petitioner, is having second position.
What is this?
Now the Executive Council's resolution, my lord, page 39.
No, page 38. What is this?
My lord, it is, my lord,
Page 35 is the
handwritten-
eligibility list.
handwritten, my lord, copy, my lord, this typed copy, my lord.
No.
Page
What is the document? Tell me. 35 is the eligibility list.
Yes, my lord.
And out of which now, and page 38 is the marks
Marks got
scored
the-
by,
By the selection committee, ma'am.
huh?
By the selection
My
committee.
lord,
Only 7 candidates appeared.
7 candidates appeared out of 17, and they have got those marks, my lord. And
What is the scheme of the selection? Scheme of the selection?
my lord, it is as per UGC, my lord, regulations, my lord.
Yes, what is that?
My lord,
Test,
my lord.
interview,
No, my lord, interview, my lord.
only interview.
Only interview.
Interview and your mark sheets or whatever your documents, testimonials.
Yes,
So this is page 38 is the interview marks,
interview marks, my lord.
along with whatever you have done.
Yes, kindly.
Along with the
see
marks
the
given,
Interview 20 marks, my lord. In the right hand column, my lord,
interview is only that column 3, Roman 3.
Roman 3, my lord. And domain knowledge of teaching skill, 30 marks.
The remaining is all breakup regarding your academic records,
Yes, my
research
lord.
and all
From
that.
SSLC onwards, my lord.
Roman 3 is the interview marks.
Yes,
Maximum is 20.
maximum 20, and 2 is the domain knowledge and teaching skill, 30.
So where is the dispute now?
My lord, regarding that eligibility aspect, my lord, that specialization aspect, whether the
So
private,
you're going back to the eligibility.
my lord,
After your documents and your testimonials have been scrutinized
my lord,
and the interview has been held,
the page,
marks has been given,
my lord,
you appear to have received 57.31.
second position,
Respondent number 6, 59.54.
first position.
Now you are saying that the very eligibility criteria has not been fulfilled by the respondent number 6.
6, my lord. Now, kindly turn to page 39, my lord. The resolution for appointment, my lord, page 39. It's a typed copy of next page, my lord. 39A. Resolved that the following panel of candidates be recommended to the Executive Council, Dibrugarh University, for appointment as Assistant Professor, post number 2, in the Department of Applied Geology, Dibrugarh University, Dibrugarh. First one, Mr. Pranjit Kolita. Second one, Dr. Onanya Sutia.
This is the resolution.
Page 39, my lord.
This is the resolution
my lord,
taken by,
taken by the selection committee, and it has been forwarded, recommended to the executive council. And accordingly, my lord, the first, my lord, candidate, Ranjit Kolida, private respondent number 6, he got, my lord, appointed as an assistant professor in applied theory.
oh, where is the original resolution? This is what, just typed copy.
Next page, my lord. 39A.
This also same thing.
Same, it's a typed copy of this 39A, my lord.
What is the authenticity of this document?
My lord,
Resolution,
it's not disputed, my lord. In
three
the
names in
affidavit in
writing.
opposition also, my lord, it is a admitted fact, my lord.
Where's the third person?
My lord, no third person has been, my lord, indicated, my lord. Only this first and second.
So selection committee comprises of only two persons,
Two are,
only two persons.
only
Two, my lord.
And this resolution is a part of which document?
My lord, it's a, my lord, since it's a response to the RTI application, my lord,
Response to the RTI.
application.
It says inner page 2. Inner page 2.
Inner page 2, my lord,
On top, inner page 2,
my lord,
running page 39,
my lord.
inner page 2.
These documents
Where
have
is,
been.
where is the inner page 1?
My lord, that not furnished, my lord. My lord, in response to the RTI application of the writ petitioner, my lord, some documents have been, my lord, enclosed along with the RTI response. But the page number 1, it has not been annexed, my lord. So number of RTI applications have been submitted, my lord. Right. My lord, since, my lord, it is not disputed that he got first position and the writ petitioner got the second position. And
Maybe,
accordingly,
see,
my lord,
why I'm saying is this, because normally you don't get a piece of paper saying this is the resolution and give it to somebody.
my lord,
Resolution of what? There has to be some beginning also.
my lord.
You have the records with you.
that record is not available with me, my lord.
Hmm?
The record is not available with me, my lord.
Not available. Because you have shown me the marks and all that, okay, fine. But when the resolution comes, it's just one separate page, says resolution and 2 names.
I agree with your lordship, my lord, but in response to my now numerous RTI applications, my lord, they have not, my lord, responded with all the documents, some part documents, my lord. I have stated in my affidavit as well as written regarding them. And another thing, my lord, since it's not disputed that I am in position number 2, my name has also been recommended to the EC along with the private respondent number 6. So, my lord,
Number 1 is the respondent number 6.
6, that is not disputed, my lord.
Okay, please continue.
My lord. Now, we,
No, just not pointing out to my lord, is that page 39, my lord, 39 in the continuation of the original, page 38, my lord. 38, that is mark allocated by the selection committee, my lord, and 39, page 39 is there, resolution passed by the selection committee, my lord.
under the resolution of protection.
38, 39.
38,
They are together.
my lord.
Okay.
But the resolution should carry the name, signature, seal, etc., my lord.
Huh?
My lord, page 39, my lord, there is nothing, my lord.
No, that is why I'm asking all these questions.
Milo.
Nobody's pointed to point out. Only answer you give is that it is not disputed.
My lord.
Now, that matter, that you lord.
And the selection committee is not for a school teacher or some headmaster. It's for a professor.
No, in our affidavit, my lord, we have annexed, my lord. Annex is the market, this result sheet of this selection committee, my lord, along with the signature of the selection committee, my lord. That will be at page page 7 of my affidavit in opposition, my lord.
Okay, then, but what is this page 39 then? This is an abstract.
Extract, my lord.
Anyway, please continue.
My lord. Now I will turn to the affidavit in opposition filed by the Dibrugarh University.
No, before that, what is your case?
Milord, the private respondent number 6 lacks the eligibility, Milord,
Specialization.
specialization.
Your main case is that there's no
No
specialization.
specialization.
You have the specialization?
Yes, ma'am.
Okay. So
Right.
preference should have been given to you.
Yes, ma'am.
Okay.
So, Milord,
Specialization in geochemistry
and
or
petroleum
petroleum.
technology.
No, not and, it's slash oblique.
Or, Milord,
You are petroleum or geochemistry.
geochemistry, Milord.
So one may have geochemistry or one may have petroleum geology.
Milord.
Both are accepted.
Both are accepted.
You have geochemistry.
Geochemistry.
Private respondent does not have either
Does
of
not
those.
have geochemistry.
Okay.
So, Milord, I beg to
So,
draw your lordship attention to page 43,
no,
Milord.
before that, where is your pleadings? The grounds for which you have challenged this?
Milord. Page 5 onwards, Milord.
You refer to a particular paragraph?
Milord, para 3, page 5. First few lines, Milord.
Has got no specialization.
The writ petitioner humbly begs to state that the private respondent number 6, Sri Pranjit Kolita, has not got the specialization in geochemistry or petroleum geology as stipulated in the aforementioned advertisement dated 18/10/2016. And in spite of that, the said private respondent number 6 has surprisingly been appointed as an assistant professor in the said Department of Applied Geology after the interview process to the said post got completed. It is also relevant to state here that from the contents of the notification under reference number so and so and the dissertation title of the private respondent number 6, it is clear that the said private respondent number 6 does not have the stipulated specialization as per the advertisement. Now, para 4, next page. That the writ petitioner states that immediately thereafter, writ petitioner has preferred an application dated 26/7/2017 to the PIO cum law officer Dibrugarh University under the RTI Act 2005, seeking information regarding the selection process to the aforementioned post, including the total number of applicants having specialization as per the advertisement, as well as the photocopies of documents submitted by Sri Pranjit Kolita for the above mentioned post. Thereafter, another RTI application dated 16/8/2017 has also been preferred by the writ petitioner in this regard. Furthermore, the writ petitioner also preferred a representation dated 27/7/2017 to the Vice Chancellor of Dibrugarh University, praying inter alia to conduct an inquiry and kindly withhold the effect of the aforesaid appointment until the inquiry is completed, with copies of the said representation to the respondents concerned, including the registrar, the dean, and the head of the department concerned. Next page, para 5.
That's okay. You don't have to read everything. I've read it.
Milord.
Now,
So,
where's
Milord,
where's the appointment order of the respondent number 6? Has it been issued?
No, Milord. Milord, appointment already, Milord, that entire process has been completed, but I have not been furnished with the appointment letter as yet, Milord.
So has he been appointed?
Yes, Milord.
When?
Milord.
And he also joined the post Malo on 26/7/2017 Malo. From that date, he is honored, he is holding the post Malo till today Malo. More than 8 years have already elapsed Malo.
26/17.
26/7/2017 Malo.
This is on the day on which the petitioner also preferred application.
Yes, Milord.
Same day.
Same day. Now, since the crux of the matter is regarding specialization aspect, Milord, so I take your lordship straight to the contents of the affidavit in opposition.
Paragraph 5, they say that none of you would have the subject
Milord.
specialty.
I'll read slowly, Milord. They're very, very important, Milord. And I have also filed affidavit in reply in response to that paragraph 5 and 6. Milord, page 44.
Yes, read paragraph 5.
Page 44, Milord. May I read?
Yes.
Paragraph 5. That with regard to the statements made in paragraph 3 of the writ petition, the opponent states that screening committee constituted for scrutiny of the applications received in response to the advertisement dated 18/10/2016 for selecting and making appointment to the post of assistant professor in the Department of Applied Geology, Dibrugarh University, on scrutiny of applications found that, it is very, very important, my lord, found that no candidates have geochemistry as specialization either in PhD or in any research work carried out during post-MSc period. The screening committee therefore considered that candidates having geochemistry as a subject in the MSc syllabus should be considered for shortlisting, and on that basis, candidates should be called for interview. My lord, my lord, my lord, I have already responded in the affidavit in reply, my lord. I will come to that aspect little bit later. Moreover, the respondent 6 had also pursued and completed course with isotope geochemistry as a subject. On comparison of the contents of the syllabus of the MSc course of the writ petitioner and the respondent 6, the selection committee found that respondent 6 was in a better footing than the writ petitioner, as he was found better specialized in geochemistry than the writ petitioner. During scrutiny of the application of respondent 6, along with relevant documents annexed thereto, the screening committee found that the respondent 6 is a registered PhD scholar with a major component of geochemistry in his research work. The screening committee further found that in the PhD certificate of the writ petitioner, it was written as PhD in applied geology. Therefore, the writ petitioner cannot be said to have specialization in geochemistry. On the other hand, the respondent 6 had the knowledge of both geochemistry and petroleum geology. In other words, the selection committee found the candidature of respondent 6 to be in much better footing than that of the writ petitioner, and accordingly recommended the name of the respondent 6 for making appointment to the post of assistant professor in the Department of Applied Geology, Dibrugarh University. Next page.
Now, what is your qualification?
MSc in which specialization in geophysics or petroleum technology.
Geophysics,
Geochemistry
geochemistry.
or petroleum technology.
No, you're having both. Your qualification,
My lord, I have specialization in geochemistry.
geochemistry,
And I have
specialization.
got PhD research paper also. My lord, I will come to that a little bit later, my lord. In my affidavit in reply, my lord, I have elaborated in everything, my lord. Next, my lord.
No, at this moment, let us see.
My lord.
According to you, you have the PhD in geochemistry.
My lord, geochemistry is a part of applied geology. So, my lord, it's ludicrous, my lord, that PhD in applied geology does not mean that he is not PhD in geochemistry. Geochemistry is a part of applied geology, my lord, subject. So the writ petitioner is having PhD in applied geology, but as per the screening committee, it does not mean that he has got PhD not in geochemistry.
Then what about respondent number 6? What is the qualification?
He only, my lord, got that MSc degree, where is a chapter is about that geochemistry as well as petroleum technology. I'll come to that a little bit later, my lord. Since, my lord, this is an affidavit in opposition filed by the Dibrugarh University. So the next paragraph that will clarify the situation. Position. My lord, we can skip, my lord, paragraph 6, my lord, next page. Paragraph 7. That with regard to the statements made in paragraph 5 of the writ petition, the opponent denies that she had approached the authority concerned several times with regard to the anomaly in the selection appointment of the respondent 6 and for taking urgent steps in the matter. The deponent states that the respondent 6 was selected by Statutory Selection Committee, Dibrugarh University, after conducting the interview in a free and fair manner, and also by complying with the laid down procedure, and there were no anomalies in such selection as alleged by the writ petitioner. The deponent admits that the writ petitioner had submitted RTI applications before the authority concerned of Dibrugarh University, against which she had been provided with the information as sought for. The writ petitioner was provided with all the information regarding the selection and appointment of the respondent 6, and no material facts has been concealed therefrom as alleged. Para 8. That with regard to the statements made in paragraph 6 of the writ petition, deponent states that as against the application dated so and so, submitted by the writ petitioner to the VC Dibrugarh University, the registered Dibrugarh University by the office letter dated so and so duly furnished the information to the writ petitioner as sought for with regard to the appointment of assistant professor in the Department of Applied Theology, Dibrugarh University. It was clearly stated in the aforesaid letter that pursuant to the advertisement number so and so dated so and so, 17 candidates applied for the post, out of which 10 candidates were found eligible to be called for the interview by the screening committee of Dibrugarh University. The screening committee duly scrutinized the applications taking into next page, page 46. Taking into consideration the qualifications of the candidates vis-a-vis the specialization required for the post. Pursuant to the report of the screening committee, the selection committee conducted an interview on 27/6/17 in a free and fair manner. On scrutiny, it was found that the selected candidate had fully studied and passed geological and geochemical exploration, 5 credits, isotope geochemistry, 3 credits, petroleum geology, 5 credits, and exploration and development of oil and gas fields, 6 credits, which are all related to the required specialization for appointment to the aforementioned post. Further, the selected candidate has cleared CSI UGC NET in Earth, Atmosphere, Ocean and Planetary Sciences, in which a major unit of the syllabus consisted of geochemistry. Consequently, the Executive Council, Dibrugarh University, duly approved the recommendation made by the selection committee for making appointment to the respondent number 6, and on such giving approval, respondent 6 was duly appointed as assistant professor in the Department of Applied Geology, whereupon he also joined the said post on 26/7/2017. We can skip the other paragraphs, Miller, particularly regarding that eligibility, that requirement, Miller, specialization. Miller, these 2 paras, Miller, incorporated, Miller, entire aspect. Now kindly turn to my affidavit in reply. Particularly regarding that specialization aspect. Paragraph 5 and 6, Miller. Page 60 onwards. Running page 60, Miller, paragraph 5. That with regard to the statements made in paragraph 5 of the aforesaid affidavit in opposition, while putting the respondent deponent to the strict proof thereof and reiterating the statements made herein above, as well as in the writ petition, this deponent further begs to state, with respect to the respondent deponent's averment, that no candidates have geochemistry as specialization in either PhD or in any research work carried out during post-MSc period. And as such, the said screening committee purportedly considered that candidates having geochemistry as a subject in the MSc syllabus should be considered for shortlisting, and on that basis, candidates should be called for interview. That the said impugned decision of the screening committee as regards shortlisting is totally unacceptable, and it was smeared with clear biasness towards the private respondent 6, since the writ petitioner has got the required specialization in post-MSc period, including her PhD topic, entitled A Study on Petrography, Geochemistry, and Reservoir Characteristics of the Tipam Sandstone Formation from a few oil fields of Upper Assam and the type section of the Tipam Hills. Unlike the said private respondent 6, the PhD topic of the writ petitioner itself indicates that the specialization of the writ petitioner directly matches the specialization in the advertisement, that is geochemistry or petroleum geology. Moreover, the writ petitioner has got a research paper in geochemistry entitled A Study on Geochemical Composition and Source Area Weathering of the Tipam Sandstones from a Few Oil Fields of Upper Assam Basin, India, in the Indian Journal of Applied Research, volume so-and-so, ISSN so-and-so. Next page, Miller. Also, page 61. Also, the writ petitioner got a book chapter in geochemistry entitled Geochemistry of the Tipam Sandstones from a Few Localities of Upper Assam Basin, India, in the book Recent Trends in Earth Science Research with special reference to ANI India. Today, and tomorrow's printer and publishers, page number so-and-so, ISBN number so-and-so. Also, she has a research paper in petroleum geology entitled A Study on Reservoir Characteristics of the Tipam Sandstones of Miocene Age from Upper Assam Basin, India, in the Journal of Indian Association of Sedimentologists, volume so-and-so, ISSN so-and-so. In view of this, it is important, Miller. In view of this, the specialization of the writ petitioner in geochemistry or petroleum geology is directly supported by these publications, which is not the case of the private respondent number 6, lacking the said specialization. Next para. It is stated that the writ petitioner deponent along with some other candidates have got their PhD research publications in geochemistry or petroleum geology, excluding the private respondent number 6 in the instant matter. Despite the contents of the advertisement dated so-and-so, the said affidavit in opposition is silent about the specialization in petroleum geology, and it focuses upon the specialization in geochemistry only. The said respondent 6 has not pursued and completed any specialization course with isotope geochemistry as a subject as sought to be indicated in the said affidavit in opposition. Since it is only a part of MSc course, it is important. Since it is only a part of MSc course in geology, specialization indicates the confinement or applicability to a particular subject only, which is not a part of a vast MSc course. It is also not true that the respondent 6 was in a better footing than the writ petitioner, as he was found better specialized in geochemistry, or that the candidature of the respondent 6 was in a much better footing than that of the writ petitioner, as stated by the respondent deponent. It is humbly stated by this deponent that candidates having geochemistry as a subject in the MSc, next page, Miller, syllabus could neither be regarded as having the required specialization nor be considered for shortlisting, as because specialization geochemistry petroleum geology cannot be equivalent to a mere chapter unit amongst the huge numbers of chapters units incorporated in a vast syllabus of MSc applied geology, giving only a sketchy outline of the said study areas. Further, in the MSc syllabuses in the universities in India, geochemistry is an integral part of geology subject, and also considering the environment in the said affidavit in opposition that candidates having geochemistry as a subject in the MSc syllabus should be considered for shortlisting, it is crystal clear that all the MSc geology examination past students would have specialization in geochemistry, paving way for opening a floodgate to all the MSc geology examination past students, including candidates Ms. Rupjyoti Hazarika, Mr. Bitupan Mojumdar, etc. It may be relevant to point out here that in the said affidavit in opposition, a comparison is sought to be drawn unjustly in between the area of specialization of the PhD candidates, including the writ petitioner, on one hand, and that of the MSc syllabus of the respondent 6 on the other, with an oblique purpose in place to place the name of the respondent 6 in the shortlisted candidates for the interview. It is stated that the relevant records would reveal that the writ petitioner has been awarded PhD way back in 2015 with required specialization, whereas the private respondent number 6 is only an MSc, that too without any specialization in post-MSc period. Further, the factual context of the instant matter, it is clear the decision-making process of screening committee as well as selection committee was affected by subjectivity and biasness in favor of the said respondent 6. On the other hand, it is stated in the said affidavit in opposition that the screening committee found that the respondent 6 is a registered PhD. Next page, Miller. It is important, Miller. Screening committee found that the respondent 6 is a registered PhD scholar with a major component of geochemistry in his research work, and consequently, as per the screening committee's purported opinion, the respondent 6 had the knowledge of both geochemistry and petroleum geology. It is surprising that a candidate having simply registered his name as PhD scholar, which is very initial starting point of the PhD course, could be regarded by the screening committee as having specialization in the area concerned, whereas finding that in the PhD certificate of the writ petitioner, it was written as PhD in applied geology, it has been opined by the said screening committee that therefore the writ petitioner cannot be said to have specialization in geochemistry. Though the post is meant specifically for assistant professor in applied geology, having specialization in geochemistry, petroleum geology, that is part of the applied geology subject. In the advertisement dated so and so. It is also stated that the PhD topic of the respondent 6 entitled Deformation and Metamorphism of the Lesser Himalayan Sequences along Didza Bomdila Dirang section, West Kameng district, Arunachal Pradesh, India, does not indicate that it is the aforesaid areas of specialization for the purpose of shortlisting him for the interview. Next parameter. That with regard to the statements made in paragraph number so and so of the affidavit in opposition, while putting respondent deponent to the strict proof thereof and also reiterating the statements made herein above as well as the writ petition, the deponent, next page, further begs to state that the credits shown against the respondent number 6 as well as clearing of CSIR UGC NET by him in paragraph 8 could not entitle the said respondent 6 for getting shortlisted to the zone of consideration since he lacks the required specialization. It is stated that if MSc syllabus is considered the basis for having specialization, all MSc geology passed out students would have specialization in every branch of geology. Similarly, if CSIR UGC NET syllabus with its numerous chapters encompassing all the areas of the subject concerned is considered for screening any specialization in post-MSc period, then all NET qualified candidates, including the aforementioned Ms. Rupjyoti Hazarika and Mr. Bitupan Majumdar, would be regarded as having the required specialization. It is also stated that full and complete information has not been furnished to the deponent till date in response to her several RTI applications, concealing some vital information as regards said private respondent 6, taking the purported plea of personal information, Annexure F to the writ petition. It may be pointed out here that a laid down procedure in paragraph 7 has not been complied with in toto, particularly as regards the relevant provisions of existing UGC regulations in connection with the selection committee specification as well as marking system followed by the aforesaid selection committee. Now, if we turn to the annexures enclosed with the affidavit in opposition by the Dibrugarh University, Miller. Finally, turn to page 57. Page 57.
Yes, 57.
Milord. It is in response to the letter of the writ petitioner, Milord. Milord, paragraph 1 and 4 is relevant, Milord. May I read, Milord? The paragraph 1, Milord. It is addressed to the writ petitioner, Milord. The advertisement for recruitment of teaching post in Dibrugarh University was made as per advertisement number so and so dated so and so, which also included the post number 2 of assistant professor in Department of Applied Geology, seeking specification in geochemistry or petroleum geology. Now, para 4. After receipt of your letter and on being scrutinized, it was found that the selected candidate had duly studied and passed the following papers related to the specialization. Kindly note that it is regarding studying and passing following papers related to the specialization. Only papers, Milord. A, geological and geochemical exploration, 5 credits. B, isotope geochemistry, 3 credits. C, petroleum geology, 5 credits. D, exploration and development of oil and gas field, 6 credits. So, Milord, the private respondent number 6 is specialist in geochemistry as well as petroleum geology, my lord, as per their contention, my lord. Serial number B and C in paragraph 4, my lord. But it's a paper, it's a subject, my lord, it's a unit of chapters, my lord, in the MSc syllabus, my lord. So some credits have been given, my lord, 5 credits, 3 credits, and 5 credits, etc. But it is not a specialization aspect as has been pointed out in my affidavit in reply. my lord. And down below, my lord, another, my lord, aspect, my lord. Further, the selected candidate has cleared CSIR UGC NET in Earth, Atmospheric, Ocean, and Planetary Sciences, in which a major unit of the syllabus consisted of geochemistry. My lord, that NET examination, my lord, it is, my lord, just an eligibility, my lord, just a test, so that, my lord, before, my lord, enrollment as an assistant professor, my lord, one will have to clear that NET examination, or he will have to clear that PhD course, either PhD or NET, my lord. So, my lord, the syllabus of the NET examination cannot be, my lord, in the specialization arena. And the subjects, my lord, indicated in paragraph 4, along with the marks, my lord, credits, my lord, is just a chapter, my lord, just a paper, not the specialization area as indicated in the advertisement. Now, if we come to the dictionary meaning of that specialization, my lord, Chambers Dictionary as well as Oxford Dictionary, my lord.
I have it here. Last time you gave,
My lord. My lord.
which one first, Chambers or Oxford?
My lord, first, my lord. First, my lord, that Advanced Learners Dictionary, my lord.
Oxford.
Oxford Advanced Learners Dictionary.
Expert in an area of work.
Specialize to become an expert in a particular area of work, study, or business, to spend more time on one area of work, etc., than on others. Many, for example, many students prefer not to specialize too soon. He specialized in criminal law. That is, my lord, for us, my lord, lawyers, my lord. My lord, since, my lord, I have passed LLB, so I am not specialist in Hindu law, Mohammedan law, criminal law, my lord, everything, my lord, constitutional law. My lord, the shop specializes in handmade chocolates. Specialization is a noun of that specialized verb, my lord. Now, Chambers Dictionary, my lord. Spatial, my lord, and the middle portion, that noun word, specialization. To make spatial or specific, to differentiate, to adapt to condition, to specify, to narrow and intensify, to become or be a specialist. That word has been defined down below, my lord. Specialist, one who devotes himself to a special subject, etc., my lord. So this is the specialization means, my lord, special arena, special, my lord, area of knowledge where one becomes expert, my lord. So the private respondent number 6 in his MSc course, he has got one paper regarding geochemistry. He has got another paper in petroleum geology. So he cannot be, my lord, regarded as a specialist in both geochemistry or petroleum geology. And there are other 3 papers, my lord. So as per the screening committee, he is specialist in all the 5 arenas, my lord. Geochemistry, petroleum geology, and other, my lord, arenas, my lord. It's a part of the MSc course, my lord. It's a part of the syllabus, a chapter and unit, my lord, where he appeared, my lord. That cannot be regarded as specialization. And the Supreme Court, my lord, is clear, my lord, regarding the contents of the advertisement, my lord. It cannot be, my lord, tweaked, my lord. My lord, as per the screening committee, my lord, there would be no, my lord, specialization arena, my lord. It will be open category, my lord. I have already, my lord, pointed out to your lordship, my lord. The specialization cannot be open, my lord. The specialization should be, my lord, only in 2 arenas, my lord. One geochemistry and another petroleum geology, my lord. Lord, may I point out that case per judgment, my lord? I have already provided a copy, my lord.
This here. What is the judgment name?
My lord,
Shekhar.
2002 3 SCC 586.
K. Shekhar.
K. Checker.
It's here.
Para 23 and 24. Only these 2 para, my lord.
You want to read?
Para 23 and 24. May I read?
Read.
If we start para 23.
Yes, read.
If we start with the root, there can be no doubt that the appellant's appointment as lecturer in 1986 was not in terms of the advertisement pursuant to which he had applied. Before any appointment could be made to the post of lecturer, the post should have been advertised together with the eligibility criteria in respect thereof. The submission of Nimhans was that since the post of lecturer was lower than an assistant professor, it was not necessary to be advertised. If this argument was accepted, it would amount to violation of Article 14 and 16. The absence of an advertisement necessarily deprived persons who could have applied for the post of the opportunity of applying for the post. The clause in the advertisement which enabled the selection committee to recommend the candidate for a lower post if the candidate was not found suitable to fill the post applied for did not give Nimhans the power to appoint the recommended candidate against an unadvertised post. Significantly, in the other advertisement on record, dated so and so and so and so, the post of assistant professor and the post of lecturer were both advertised. Now next para 24. The clause, far from allowing Nimhans the power to dispense with the advertisement of any lower post as a precondition to appointment, indicates that only eligible persons could be considered for selection. Now it is important, my lord. Once the barrier of eligibility was crossed, the selection committee could consider the suitability of the candidate for the post advertised. It follows that the appellant should not have been called for interview at all. His application clearly showed that he did not fulfill the requisite eligibility criteria for the post he had applied for because he lacked any postdoctoral experience at all. The power in the selection committee to relax the eligibility criteria cannot be read as including the power to do away with the criteria altogether. So, my lord, then paragraph 25 and 26, my lord. Then again, the post which was advertised was a temporary tenure post, and yet by virtue of the corrigendum, the posts were made permanent. It is true that the advertisement stated that there was a likelihood of some of the advertised posts being made permanent after 3 years. All that this meant was that the post would remain temporary tenure post for 3 years, after which there was a possibility of the appointments being made permanent. When the post itself was made permanent from its very inception by the corrigendum issued several months later, the post should have been re-advertised so as to give fair notice to all prospective candidates regarding the nature of the vacancy to be filled. It was not open to Nimhans to retrospectively and subsequent to the appointment change the nature of post advertised by issuing the corrigendum. 26. In any case, the corrigendum proceeded on a misinterpretation of the terms and conditions under which the center was set up by ICMR. There was no obligation on the part of NIMHANS by reason of any agreement with ICMR to absorb any employee of the center. ICMR's condition as quoted earlier merely obliged all institutes where such centers were set up to continue the work after ICMR withdrew its financial support at the end of the 5 years. So, my lord, these paragraphs, my lord, indicates, my lord, that the terms of the advertisement, it cannot be tweaked. And since the advertisement indicates that it's a post meant for the specialization in geochemistry or petroleum technology. And geochemistry and petroleum technology specialization, my lord, cannot be, my lord, that aspect cannot be considered in case of private respondent number 6. Since in his MSc course, my lord, he has only got that paper regarding geochemistry and also, my lord, petroleum technology. But in contrast to the eligibility of private respondent number 6, my lord, writ petitioner is much more better footing, my lord, with the specialization, my lord, in geochemistry as well as petroleum technology. And further, my lord, the private respondent number 6, only a PhD is, my lord, registered scholar, my lord. He has not completed the PhD course. Further, that NET examination, you know, it's only a test, my lord. One will have to, my lord, pass that test for getting the eligibility to get enrolled as an assistant professor in the university as per UGC regulation. Nothing more. So, my lord, this should not have been considered by the screening committee. So, since, my lord, he has been, my lord, interviewed, shortlisted, my lord. So, my lord, it cannot stand in the eyes of law, my lord. It is entire selection process has been vitiated. And a very biased opinion in favor of private respondent number 6 by the screening committee. That's my submission.
Okay.
May please, your lord.
Yes.
My loyal panel has already pledged that some paragraphs of my accusing my lord, I may be permitted to place again, my lord, before the lordship, my lord. That paragraph number 4 and 5, my lord. That is most important, wherein we have explained about the conditions of both the petitioner and the respondent number 6, my lord. About the eligible criteria, my lord, criteria. The paragraph 4, my lord, of our affidavit. That with regard to the statements made in paragraph number 2 of the petition, the deponent states that an advertisement being number sponsor dated 18/10/2016 was issued by the Dibrugarh University for filling up the post of 2 numbers of assistant professor in the Department of Applied Geology, which is specialization in geochemistry and petroleum geology. As against the aforesaid post, all total 17 candidates submitted their application, and after scrutiny of all the applications by the screening committee, prepared a report and also a list of list containing 7 numbers of short candidates, and thereafter the screening committee sent the aforesaid list to the selection committee for holding interview. The selection committee, after holding an interview of the candidates, including the petitioner and the respondent number 6, on 27/6/2017, duly recommended the name of the respondent number 6 to the Executive Council, Dibrugarh University, for its approval and making appointment. Thereafter, the Executive Council, the Dibrugarh University, in its 335 meeting, duly approved the aforesaid selection and recommendation made by the selection committee, whereupon the respondent number 6 was duly appointed as the assistant professor in the Department of Applied Geology, Dibrugarh University, by appointment letter under reference number 7 dated 25/7/2017, issued by the registrar, Dibrugarh University. The deponent further begs to state that in response to the various RTA applications submitted by the petitioner, the authority concerned of Dibrugarh University had duly attended and replied to the same, providing the information as sought for by the petitioner. And I come to paragraph number 5, my lord. That with regard to the statements made in paragraph number 3 of the petition, the deponent states that the screening committee constituted for scrutiny of the applications received in response to the advertisement dated 18/10/2016 for selecting and making appointment to the post of the assistant professor in the Department of the Applied Geology, Dibrugarh University. On scrutiny of the application, found that no candidates have geochemistry as specialization either in the PhD or in any research work carried out during post-MSc period. This is very important, my lord, that I have explained. The screening committee therefore considered that candidates having geochemistry as a subject in the MSc syllabus should be considered for shortlisting, and on that basis, candidates should be called for interview. Moreover, the respondent number 6 had also pursued and completed a course with a isotope geochemistry as a subject. On comparison of the contents of the syllabus of the MSc course of the lead petitioner and the respondent number 6, the selection committee found that the respondent number 6 was in a better footing than the lead petitioner, as he was found better specialization in geochemistry than the lead petitioner. During scrutiny of the applications of the respondent number 6, along with the relevant document annexed thereto, the screening committee found that the respondent number 6 is a registered PhD scholar with a major component of geochemistry in his research work. The screening committee further found that in the PhD certificate of the lead petitioner, it was written as a PhD in applied geology. Therefore, the lead petitioner cannot be said to have specialization in geochemistry. On the other hand, the respondent 6 had their knowledge of both geochemistry and petroleum geology. In other words, the selection committee found the candidate of the respondent number 6 to be in a much better footing than that of the lead petitioner, and accordingly recommended the name of the respondent number 6 for making appointment to the post of the assistant professor in the Department of Applied Geology, Dibrugarh University, Malad. In percentage, Malad, the resolution that I have, the resolution passed by the selection committee, Malad, that you will also find as annexure 1, Malad, of our affidavit, Malad. Page 7, Malad. Sorry, 7 of my affidavit official, Malad. That has already been annexed, Malad, by the petitioner, India petitioner, Malad. The page 8, Malad, page 8 is the resolution, Malad. And the resolution has already been signed by all the members of the selection committee, Malad, including the vice chancellor, Malad, of the Dibrugarh University, Malad, was the chairman of the selection committee, Malad. And this resolution, Malad, the selection committee that was placed before the executive committee of the executive council, Malad, of the Dibrugarh University, Malad, in its meeting held on 21st of July 2017, Malad. Just I am placing before a last copy of that resolution of the executive council, Malad. In second page, Malad, in second page, that resolution number 10, Malad. That's the resolution adopted by the executive council of the Dibrugarh University, Malad.
Yes.
May I please, Malad?
Yes.
Resolved that as recommended by the selection committee held from 22nd June of 27 June 2017, Mr. Pranjit Palita, son of so-and-so, Jorhat, be appointed as assistant professor, post 2, Department of Applied Geology, Dibrugarh University, in the pay band so-and-so, plus all other allowance as admissible, Malad. This executive council, Malad, considered the resolution adopted by the selection committee, Malad. And accordingly, by passing this resolution number 10, Malad, they directed the authority concerned to issue the appointment letter, and accordingly an appointment letter was issued to the respondent number 6, Malad, in persons of which he has also joined on 26/7/2017, Malad. And till now he is holding the post, Malad. At this stage, whether your lordship will interfere, Malad, with my appointment, Malad. Moreover, this petitioner, she is also holding a post in the Cotton, initially in Cotton College, now it is a Cotton University, Malad. He is already engaged, Malad. In that view of the matter, who is there any question, Malad, who had to interfere with the appointment of the respondent number 6, Malad? in para, matlab, 4 and 5, matlab, we have already explained, matlab, that the response number 6 is in a better putting, matlab, than the repetition, matlab. And accordingly, that his name was recommended by the selection committee, matlab, and selected and recommended for giving up for approval by the executive council, matlab. And according to the person to that, the executive council also, by adopting a resolution, matlab, they directed for giving appointment to that response number 6, matlab. And about this, the specialization, my trained by Mr. who is appearing on behalf of the response number 6, he will be able to explain that before the lordship, my lord.
All right. You are for respondent number 6.
My lord.
Have you filed affidavit?
No, my lord, we have not filed the affidavit.
Okay.
However, like, well, here the grievance of the petitioner is that the respondent number 6 has lack of specialization. Here, the petitioner, the respondent number 6 has been serving for the last more than 8 years. Had it been any problem or defective in his specialization, he won't be serving till date. That's another point. My lord, I'm not going to go in thorough discussion with the affidavit and the position filed by our learned standing council university. However, lord, my lord, here for the post of this applied geology assistant professor, 17 candidates participated. 17 candidates they have applied for the particular post. How out of 17 candidates, 7 numbers of candidates has been shortlisted. Thereafter, the scrutiny committees forwarded the shortlisted candidate of 7 shortlisted 7 candidates to selection committee. Thereafter, the selection committee called for interview for the particular shortlisted candidates. Accordingly, the selection committee duly recommended the name of respondent number 6 to the executive council, and the executive council of the university approved the selection recommendation made by the selection committee. This is the process done in view of the appointment of the respondent number 6. Yes, your lordship has already gone through the paragraph number 5 of the affidavit of opposition. Of the decision filed by the Dibrugarh University. So I am not going to go in details. However, here in the particular affidavit, they have swear that like the screening committee have not found any of the candidates having the particular specialization. Therefore, the screening committee considered that like candidates having geochemistry as a subject in the MSc syllabus should be considered for shortlisting. Accordingly, it has done in that way. The learned counsel for the petitioner has pointed out that regarding the PhD, if your lordship see the advertisement in the particular qualification and experience, the column, the page 15, Roman letter, yes, page 15, the column of assistant professor, minimum qualification and experience, in the subclause 2, your lordship will find that besides fulfilling the above qualification, the candidate must have cleared the national eligibility test conducted by the UGC, CSIR, or similar test accredited by the UGC like SLET, SET, or PhD degree. PhD degree was not a mandatory qualification at the point of time. Therefore, bringing in record that making submission by the petitioner that like respondent number 6 was just registered in a registered PhD scholar. That cannot be, it won't be suffice because at that point of time, this PhD was not mandatory qualification as per the advertisement.
You have net?
My lord?
Do you have net?
Yes, I have net, my net, my lord.
You have net, isn't it?
Yes, net, I have it.
So it says net, SLET or PhD.
Yes, I have my lord, I have.
So you may not have PhD, but
I have
you have
my
net.
lord. Your lordship may have kindly have annexure 4, which annexure 4 of the appetitive opposition filed by the university. In the particular documents, all the details has been read out by the learned counsel for the petitioner. So I'm not into that, but I'm not reading it again. However, this is also a part of my submission that like the respondent number 6 had all this qualification and all this specialization, and as such, he was selected for the he was appointed.
You're relying upon paragraph 4.
My lord, yes. And also, my lord, I am also referring to paragraph, annexure 1 of the active opposition filed by the university. In that particular document, if your lordship see, respondent number 6,
Which one? Page number?
my lord, it's not running letter, but
Whose affidavit?
filed by the university, my lord.
Which para?
Annexure 1, my lord. In the page 7.
Yes, page 7.
Yes.
What about this?
The name of the respondent
Hmm?
affidavit in opposition filed by the university.
Yes, what do you want to
Yes.
show me?
Yes, my lord, my name will be found in serial number 5, Pranjit Kolita.
Yes.
Your lordship will see after all this record performance, research performance, as well as moment of knowledge and teaching skills, interview performance, after all this marks has been included, my total mark I have scored is 59.54. And whereby the petitioner, serial number 1, my lord, petitioner, she scored 57.31, which meaning thereby I have scored more marks than her, as per the record maintained by the selection committee. In interview performance, petitioner scored 10 marks and respondent number 6 scored 17 marks. That's how marks were distributed as per this chart.
You scored very well in the interview, Max.
My lord. Lordship, I am placing some citation before your lordship. Your lordship can kindly have. I'm placing 3 citations, my lord. The first one is coordinate bench of this honorable high court, my lord. Here the issue was here in this case the petitioner, this is same university and then the same post applied geology at a point of time. Here the issue was,
Which case?
my lord, this is Dimple Dole,
Dimple Dole.
my lord,
Okay.
versus Dimple University. My lord, here the issue was the
Yes.
petitioner challenged the qualification of the respondent, private respondent, and also the merit of selection process. Here the Honorable Court has found that like regarding the qualification, it is settled because during at that point of time, in this case, the petitioner has challenged cautioned that the private respondent does not have a PhD degree at that point of time. However, at that point of time, due to COVID pandemic, PhD requirement was exempted at the point of time of a selection process. Therefore, it is exempted in this case. And regarding the selection process, the Honorable Court has come to a conclusion that Lordship may kindly have bearer number 19, 15, my Lord, first of all. Admitted. May I read, my Lord? Admittedly, the petitioner and respondent number 6 were the candidates who have participated in the interview held on so-and-so, pursuant to the advertisement that is so-and-so, for filling up the post of assistant professor in applied theology. The selection committee have found the respondent number 6 more meritorious, has selected and appointed her as an assistant professor in applied theology by appointment order that is so-and-so. Paragraph number 19, my Lord. Having considered the categorical stance of the respondent authority and accepting experts that the PhD topic of stable carbon stable means geochemistry, it would not be appropriate for this court to have a different view with regard to specialization, as the court do not have the expertise on the subject. Therefore, this court is of the view that since both the petitioner and the respondent number 6 having been participated in the interview based on the respective accepted specialization and the qualification, the selection would be based on the merit in the interview. The selection committee has found the respondent number 6 more meritorious and accordingly appointed the respondent number 6 as assistant professor in applied geology. Here, the court has not interfered with the expert opinion of the selection committee. Another citation, my Lord, is
that what you want to stress?
yes, my Lord.
Court should leave it to the expert committee.
Yes, my Lord.
Okay. Another one?
Another one was subordinate, coordinate the bench of our new High Court, my Lord, Baharul Islam versus State of Assam.
Yes.
Here also the similar issue. The court has raised it regarding the specialization. The court has raised it upon the experts.
Which paragraph?
My Lord, I'm referring on paragraph number 31. We agree that Mr. So-and-so learned counsel that it is not appropriate for this court to sit in appeal over the opinion of the experts who are of the view that political science and public administration are interrelated and interchangeable subjects, and hence a candidate who possesses master degree in public administration is eligible for the course of lecture in political science and vice versa. We are told that a large number of persons having qualification in the interrelated subjects have been appointed readers, professors, lecturers, and are continuing as such in various college and university in the state. The dispute was that the petitioner accordingly this petition was dismissed. The dispute was political science and public administration, the appointment of political science and public administration, my Lord. Here also the Honorable Court lived upon the knowledge of the expert committee regarding the merit selection process.
This paragraph 31.
My Lord.
has been quoted from the Supreme Court decision.
Yes, my lord.
Otherwise, this judgment has only 9 paragraphs.
Yes, my lord. Sub-para of, para 8.
Then the other one,
Other one, my lord, is, our Supreme Court of India. Here also, the challenge was, there is an appeal, it is an appeal, the appeal was made.
paragraph numbers. What are you relying upon?
My lord, I am relying on paragraph number 31. Thirty-one, 33, 48, 54, 54.
Oh, you need not read all this.
My lord.
See,
Here, my lord,
this is what was quoted in the other judgment.
yes,
So it's from that case only.
yes, my lord, yes.
Paragraph 31 in that judgment
Yes,
is
yes,
from this
yes.
judgment. So you need not repeat that. Same thing.
Here, my lord, the subject matter is the appellant appointment was challenged by the respondent. Here, the advertisement was for the post of readers in public administration. Here, the respondent has challenged the appointment of the appellant. The fact of the case will be, you should find on, in page, paragraph 4, 5, and 6.
What was the qualification of the appellant?
My lord, my qualification is MA public, political science, MA in political science. And then the respondent qualification was MA in public administration. The advertisement was for the post of reader in public administration in a university. The appointment was challenged by the respondent through repetition. Repetition was allowed, setting aside the appointment of the appellant. Appellant being aggrieved by the decision of the single bench appeared before this Honorable Supreme Court.
No division bench, no writ appeal.
Appeal is there, my lord.
No, after single bench, it did not go for appeal,
My lord,
straight to Supreme Court.
first of all, petitioner, I'm confusing with the appellant and petitioner, my lord. Here, the appellant here in
Please come to the relevant paragraph, which is that
uh,
31.
31, my lord.
Just read 31.
It may be mentioned that on the clarification sought from the UGC whether a candidate who possesses a master degree in public administration is eligible for the post of lecturer in political science and vice versa. The UGC wrote a letter dated so-and-so to the registrar MT University so-and-so stating that the subject of political science and public administration are interchangeable and interrelated, and a candidate who possesses master degree in public administration is eligible as lecturer in political science and vice versa. Thus, this is the view of the UGC, which is an expert in academic matters, and the court should not sit in appeal over this opinion and take a contrary view. Paragraph number 33, my lord. We agree that Mr. So-and-so learned counsel that it is not appropriate for this court to sit in appeal over the opinion of the expert who are of the view that political science and public administration are interrelated and interchangeable subjects, and hence a candidate who possesses master degree in public administration is eligible for the post of lecturer in political science and vice versa. We are told that a large number of persons having qualification in the interchangeable interrelated subjects have been appointed readers, professors, lecturers, and are continuing as such in various colleges and universities in the state.
So public administration and political science are interchangeable, and person having master degree in either of those can apply for the post of lecturer.
My submission is it depends on the court has left the merit of selection process upon the expert of the committee.
And in this case, the expert was the UGC.
UGC
clarified.
Hmm.
The UGC has clarified a person is eligible to be appointed as professor in public administration, even if he has the master degree in political
Yes,
science.
Lord.
Because these two subjects are interrelated. So that is the sum and substance.
Yes.
And court also accepted. The
Yes.
experts have said it, so we go by that.
What I wanted to bring is that regarding the expert bodies of the selection committee, the 54 also, my lord. In my view, the omission in the regulation cannot be said to be unintentional or a case of cases omissions. In my view, the expression appropriate subject was intended to cover the post of reader, and once the expert bodies have indicated that the applicant who had a postgraduate degree in political science was eligible to be appointed to the post of reader in public administration and had been rightly appointed to such post, it is normally not for the court to caution such opinion unless it has specialized knowledge of the subject. Paragraph 56. In such circumstances, I agree with my learned brother that the judgment of the High Court impugned in this appeal cannot be sustained. The appeal is accordingly allowed. The petition filed in the High Court by the respondent university is dismissed, and appointment of the respondent as reader in public administration is upheld. This is what I wanted to emphasize, is that as the selection committee is a member formed with the expert bodies. Therefore, whatever they have after scrutiny all the documents, the performance in the interview as well as the specialization in the BSc degree or maybe a MSc, as well as other relevant knowledge the respondent 6 has. Accordingly, he was appointed to the particular post. Therefore, the appointment of the petitioner, the appointment of the respondent is correct, and there is no illegal or biased way of in the selection process.
That's all.
I am pointing out to for Lordship, my lord, this paragraph number 8 of our affidavit, my lord, in opposition.
Yes. What is there?
Yes, that we have explained about the eligibility criteria of the respondent number 6, my lord.
All right.
That he has, the respondent number 6 has already fulfilled the criteria laid down in the advertisement, my lord.
Okay, I'll consider.
Para 8, my lord.
And the last submission is from the last more than 8 years, I have been serving in the university in the particular post, And even though the petitioner had prayed for interim of in his writ petition, in her writ petition of staying the appointment of the respondent number 6, however, there is no stay as of now. Therefore, this petition may be dismissed.
Okay.
My lord, I'll take only 2-3 minutes, my lord. Since the time is ticking away, my lord. I take straight away to page 44 again, my lord. My lord, I agreed with my learned friend that this honorable court does not have that academic, that expertise regarding those complicated academic issues, whether political science, public administration, vice versa, my lord. But here, my lord, the issue is very clear, my lord. My lord, so page 44, my lord, again, only 4-5 lines, my lord. Page 44 and 57.
You have read already these paragraphs?
Page 44, paragraph 5.
You have already read all these.
My lord, only 3-4 lines again.
So I'll consider and pass necessary orders.
My lord.
What is there to?
My lord, since, my lord, the case record is clear, my lord. Supreme Court is clear. The screening committee, the selection committee cannot tweak the advertisement, the terms of the advertisement, and cannot relax any condition, my lord.
Yes.
Any stipulation, my lord, herein, my lord, the specialization aspect. The 5th and 6th line, my lord, that is very, very important, my lord. In response to all the submissions made by my learned friends, my lord.
Right.
Paragraph 5.
This is the affidavit in opposition.
Affidavit in opposition.
Filed by the opposite party.
Yes, my lord.
You are relying upon that.
Yes, my lord. They have admitted, my lord, the relaxation. The 7th line, my lord. The screening committee therefore considered that candidates having geochemistry as a subject in the MSc syllabus should be considered for shortlisting. On that basis, candidates should be called for interview. So they have relaxed the criteria, my lord. Very, very important, my lord. Prior to that, my lord, the opening sentence, my lord. Before that, my lord. On scrutiny of the applications found that no candidates have geochemistry as a specialization either in PhD or in any research work carried out during post-MSc period. So, my lord, for that relaxation, my lord, they have not been empowered. In the eyes of law, they cannot relax the stipulation, my lord, that criteria regarding specialization. Otherwise, my lord, other candidates will, my lord, take part in the entire selection process, my lord. All the MSc candidates having NET, my lord, or PhD. And, my lord, 6-7 lines from bottom, my lord. It is very, very important, my lord, and very ludicrous, my lord. The screening committee further found, my lord, from the bottom, my lord, 8-9th line. This one sentence, my lord. It will, my lord, clarify the situation, my lord. The screening committee further found that in the PhD certificate of the writ petitioner, it was written as PhD in applied geology. Therefore, writ petitioner cannot be said to have specialization in geochemistry. My lord, entire arena is applied geology. The assistant professor is in applied geology. Writ petitioner got PhD in applied geology, and geochemistry is a part of that applied geology subject, the specialization. But since she has got PhD in applied geology, so the screening committee opined that she doesn't have that geochemistry specialization. Ridiculous, my lord. And now, my lord, 57, only that page, my lord. From their affidavit, they have admitted the facts. 57 plus 4. Only this paragraph, my lord. After receipt of your letter on being scrutinized, it was found that a selected candidate had duly studied and passed the following papers. Milord, is it, Milord, specialization, Milord? Following papers related to specialization. Then 4 papers were given, Milord. Some marks, some credits, 5 credits, 3 credits, 5 credits, 6 credits. So, Milord, the private respondent number 6 is specialized in 4 subjects, Milord. Analogy can be drawn, Milord. I am an LLB, Milord. Milord, in LLB course, Milord, criminal law, Hindi law, Mohammedan law, Milord, constitutional law, Milord. So I am expert in all those arenas, Milord. Can it be, Milord, accepted, Milord? I am a specialist in Hindu law. I am a specialist in Mohammedan law. I am a specialist in constitutional law. Can it be accepted, Milord? It's a part they have admitted, Milord. Following papers related to specialization. Only paper, Milord. And then again, Milord, regarding net. In the paragraph 4, Milord. Further, selected candidate has cleared net in so-and-so topic in which a major unit of the syllabus, again, Milord, syllabus, major unit of the syllabus consisted of geochemistry. Now, can it be accepted, Milord? Is it specialization, Milord? Can this honorable court cannot delve into that aspect, Milord? This honorable court does not have that complicated expertise regarding those academic issues, Milord. One clears net, then he is specialist in geochemistry, Milord. Can it be, Milord, acceptable, Milord? In my syllabus, Milord, I have Mohammedan law, so I am specialist in Mohammedan law, Milord. Can it be accepted?
I'll consider and pass.
Page 44 and 57 of their affidavit in opposition, Milord. Clearly admitted facts, Milord. This honorable court can interfere, Milord. Milord, the private respondent number 6 is only an MSc, Milord, and he doesn't have those, Milord, specialization.
Okay.
And I have got that specialization, Milord. I have got PhD, I have got NET, Milord, and particular in that arena, Milord, geochemistry. My affidavit in reply will clarify the entire.
All right, please write. Heard Mr. PJ Fugan, learned counsel for the petitioner. Mr. NC, MC, isn't it? MC Das, learned senior counsel and your senior counsel.
Senior.
And standing counsel, Divrugarh University for respondent numbers
1 to 5.
1,
1 to 5. 1, 2, 3, 4, and 5.
1 to 5. And Ms. T. Wapangla,
My lord.
learned counsel for respondent number 6. Hearing concluded, judgment reserved.
Most obliged.
Remaining matters, we'll have to take it up some other day. Huh? Which is item 8, isn't it?
Thank you.
Courtmaster will give you inform the courtmaster if there's an interim order and all that. One order will be passed in each case.
Consider